We are streaming.
Right. I will go ahead and call the meeting to order. Kim, you want to call roll?
Yes. Joan Corbin.
Present.
EJ Giovanetti.
Here.
Barry Lindahl.
Here.
Catherine Lucas. Here. Luke Martz.
Here.
Joel McCray.
Present.
Monica McHugh.
Present.
Jackie Schmillen.
Here.
All right.
All 8, so we have quorum.
All right. Can I get a motion and a second for the approval of the agenda?
So moved. Second.
I have a motion and a second. All in favor?
Aye.
Aye. Any opposed? Okay. All right, approval of the minutes. We have 2 sets of minutes. We have from our last meeting, June 19th, and from our interview on July 1st. I will call for a motion and a second on the June 19th first.
Second.
I have a motion and a second. All in favor of approving the June 19th minutes?
Aye.
Aye.
Monica, just note that I recused myself from voting on that. I wasn't present.
Sure. All right, now can I get a motion and a second on the July 1st minutes? I have a
Second.
motion and a second. All right. All in favor of the July 1st?
Aye.
Joan, you want to recuse yourself?
I was just about to say yes. Same. Thank you.
All right. Call for a public forum. If there's anyone here who would like to speak not on their case.
If they're in part of the consent agenda, they would need to speak during the
Okay,
public.
yes, and if there's anybody who has a case within the consent agenda, you can speak now as well. You have 5 minutes. Do we have anybody who would like to speak?
It looks like Brett has raised his hand.
Britt, I'll let you go ahead and speak. Nice to see you.
Thanks. Hello, everybody. I saw some important information on your agenda, and I felt compelled to speak on the topic. You know, I see a lot of familiar faces in the room. I see some people that have long represented clients and entities that they serve, Holly and Bree, and I'm not going to mention you all, but I see that you have some outgoing staff, and I just wanted to take my 5.5 minutes, 6 minutes, 7 minutes, and talk about. I just wanted to make sure that I played. Let you all know how much I appreciated Erica's leadership. I think that I'm not sure of the nice things you've said or will say, but the board has grown. I think the board has improved. I think that the work of this board is exceptional, and under Erica's leadership has just went to the next level. And then I worked with Kim very briefly, but I know that you definitely upgraded yourselves by bringing Kim on board as well. And this commission, or this, sorry, I currently work with a commission. This board is going to miss those 2 individuals. And but I know leaving it in good hands. Alex, I participated in your interview. You're a fine young man. And Charlotte, I just guess I hold out. You know, you can reach out to old staff if you'd like, if you need. Eric will tell you that I probably will steer you down the wrong road, but anyway. I just felt compelled to say something to you all. Wish you good luck, wish you great endeavors, and not knowing your new gig, your new digs, my guess is, Charlotte, they're just across the hall if you need help. Anyway, it's good to see everybody.
Thanks, Brett. I hope you're enjoying your new position as well, and
I am
And-
very much.
I'm glad
it's
to see
exciting.
you.
Yeah.
All right, do we have anybody else who would like to speak on the 5-minute forum?
Mr. Nocera, if this is when you want to speak, then you would need to speak now. Otherwise, Mr. Edwards you would get to speak during your case specifically. And
Okay, so this is separate and distinct from our case down below.
yes, sir.
Okay, thank you.
Okay. All right. Comments from the board chair. So we need to hold an election. I've had the chair long enough. I would have any nominations from the floor? If not, I do. I would like to nominate Catherine as the next board chair.
Kevin, how do you feel about this nomination?
I am okay with it.
All right.
That was a rousing. Thrill.
Not quite Sherman Pledge, but we'll.
So I have a motion. Is that a second?
That's a second.
Okay, I have a motion and a second. Do I have any other nominations?
I move nominations be closed.
Second.
Motion and a second, nominations close. All in favor of closing the nominations?
Aye.
Aye.
Any opposed? All right, all in favor of electing Catherine as our next chair? Aye.
Aye.
I,
Are you abstaining?
I'll abstain on myself. Effective next month?
Yeah, effective next month. Also, we should also elect a vice chair. Barry, do you want to say a few words?
No. What do you want me to say?
I just asked if you wanted to say anything.
No, I don't have anything to say. No.
Our wordsmither, Barry.
Yeah, I'll stick to that.
Do we have any nominations for a vice chair?
He didn't say he wouldn't do it.
No, he did not.
I move
Well,
Barry.
It's fine with me. My problem is I'm probably the one who has the most trouble getting to Des Moines because of the distance and the weather and everything else. So it's a little bit, you'd almost have to have a assistant vice chairperson to back me up.
Well, Barry, you have to remember, Catherine is now in Des Moines.
Yeah.
Both of us were in Eastern Iowa.
So I'd be happy to do it if you would like me to continue. But I'd not be opposed to anybody else stepping up and taking the role. So it's up to you.
I do have a motion to keep you as vice chair. Do we have a second?
Second.
All right, we have a second. Are there any other nominations?
I move to close nomination.
All right, I have a motion and a second. All in favor of closing the nominations?
Aye.
Any opposed? All right, all in favor of Barry as vice chair?
Aye.
Aye.
One abstention.
All right,
Thank you.
all right.
Happy to do it. Happy to work with the new chairperson as well.
You got it.
All right, so next, as we heard with Brett's comments, Erica and Kim are leaving us as of today and going across the hall to that dreaded other agency that most politicians really don't care for. So I would like to introduce Charlotte Miller, Charlotte is our new executive director, so her official date is tomorrow. And Charlotte comes to us from the Legislative Services Bureau, so she's very familiar with writing legislation, which is a great help to the board. So we are happy to have her come on board. And Charlotte, do you want to say or add anything?
Just saying thank you. I'm excited to get started. I'm just happy there's another debuter here as well. Kyle. Yeah, I'm just excited to get to work.
Yeah. All right. Next.
Don't let the door hit me on the way.
Say that. I do want to thank Erica and Kim for their years here and everything that they have done to bring things up to where it's at. You know, when I started many moons ago, we looked at every case that came through the doors, and sometimes we had some marathon meetings. And it was very nice to be able to have a new process in place so that complaints that came before the board that really did not fit within chapter 21 or 22 could be dismissed very easily. And so they've made a lot of progress, have really helped out a lot of things. And so we don't have those marathon sessions anymore. And those of us who've been new and old board members, we're very appreciative of everything that you have done. So with that, Alex. Yay.
Have one for.
One for.
These are the $1 million checks we were promised.
I'm a farmer. I don't make money like that.
Oh, it's a write-off.
Oh, Erica, we'd like to present you with that certificate.
Thank you very much.
And Kim, we have one for you as well. And
Oh,
we
so
appreciate
sweet.
everything that you two have done, and
Thank you.
glad to know that Charlotte will be able to holler at you to learn all the stuff of the trade. So thank you very much. I appreciate it. Thank you.
I appreciate they spelled my name right.
And I really appreciated my time with this board. I think this board is amazing, and I've loved learning from each and every one of you. So thank you very much.
All right, now we can get down to business on the consent agenda. Do I have a motion and a second to accept the dismissals?
Motion to approve the dismissal.
And a motion from Luke.
Second.
Second from Catherine. Any other discussion on the dismissal cases? Hearing none. All in favor of dismissing the 9 cases?
Aye.
Aye.
Aye. Any opposed? On the acceptance, we've got 12. Can I get a motion and a second on the acceptance cases?
I'll move to accept those.
Second.
All right, Luke and EJ. Any other discussion on the acceptance cases? Hearing none, we'll go ahead and accept the acceptance. All in favor?
Aye.
Aye. Any opposed? All right. All right, next.
All right, so with the House File 706, which we'll talk about later, there is a requirement for for IPIB to review and approve additional training providers for newly elected and appointed officials. I have included the training materials submission form from the Iowa Association of School Boards. They did provide their materials. We've reviewed it. The review showed that they met all the requirements in the guidance that IPIB board did approve on July 1st. And I do recommend approval of them as a provider. I did ask them, since this is the first one that we have done, I did ask them to be here in case you guys had any questions or concerns you wanted to talk about with them.
Any discussion on this? I know the Iowa Association of School Boards have had, ICAP training for a number of years at their meetings. So they are fully on board with training even before the law took effect. And because they've always been, pretty good working with us and making sure that, they've allowed all of the board members to know that there is a requirement out there.
How often do they intend to provide these trainings?
So I might let them speak, Siobhan and I think I saw you guys on
Yeah.
there.
Thanks so much for asking the question. Hi, I'm Siobhan Schneider with the Iowa Association of School Boards, and my colleague Anna Harmon is on virtually as well too. But so we plan on with the materials that we submitted. These materials are an outline for an interactive online on-demand training program that would be administered through the platform AEA Learning Online, which is a platform that our educators and administrators and many of our board members are already very familiar with utilizing. And it allows the elected officials or appointed officials to be able to take the training on demand when they're ready for it. And the really cool thing about it is because it's interactive, like they have to interact with the platform and do the true false, the multiple choice, go through the Q&A and interact with it in order to continue to advance through to complete the training. So it is designed, these materials that we've submitted to you today are designed to be on demand.
Eric, I have a question. Once we approve other organizations to do training, what ongoing obligation does the board have to follow up, if any, on what they do?
Well, in the legislation, I don't believe there's any specific thing, but in our guidance, we did require that they verify that they would provide the training. It'd be at least an hour, not more than 2. That they will ensure that they provide certificates of completion, and that they will continue to work with public officials to get those trainings. So there is no specific ongoing review of their materials. Perhaps that's something that the board in the future would want to look at as the law changes, if there's any changes in the law, but there is nothing specific in House File 706 that has an ongoing oversight other than what we've asked for in the guidance.
Okay, well, thank you.
One of the things we discussed today in training, our training committee, was whether we would want to require these to be live. And the thought process we had to, not necessarily in person, but live. And this morning we kind of came to the idea that we would prefer it to be live. We didn't vote on anything. Right. But one of our the point of the conversation was, and you can't just like play it in the background while you're continuing on your work. And this assuages some of our if there's a click as you go, this assuages some of our concerns that people weren't going to pay attention.
Yeah, and because I know when I take continuing ed, if there's not something that I have to do and answer, it's tough to stay focused on it. Will this training also be allowed, or will this training also be conducted at the convention that's held every year as well?
Yes, and because we haven't had the opportunity, everybody's kind of learning their way into what's the proper process you guys want to use to carry out House File 706. We decided internally, okay, we'll get this, the online training materials submitted to you guys for your review. And then we're going to do a separate submission for what we have planned in addition to that, which is we have some materials that we'll be submitting in the future for your review to provide a 2-hour-long custom workshop. And that would be where one of our attorneys goes and works directly with an individual board and does a customized training opportunity on this topic. And then we also intend to have, and we've scheduled for a training, an in-person training opportunity at our convention. So we, as a group internally at IASB, we looked at this and said, okay, well, we'll do a submission to IPIB for approval of each of those sets of materials, just so that we're trying to be as comprehensive as possible in making sure that what we have aligns with your requirements.
Awesome.
Okay.
It looks really thorough, and I was just going to ask, maybe this is more for a training committee question than it is necessarily for the school board association. And I don't object to the fee. That's fine if you guys have invested the time and the money into the training. But I guess, how do we want to make sure that there's an opportunity for individuals to know that currently IPIB provides free training, and where, you know, I don't know what our plans are for our own personal training platform or just continuing our training setup now. I guess I want to make sure that it's kind of like the FAFSA or tax returns or things like that.
So in the legislation, it did require IPIB to provide at least one training for free. Currently, we have 4 trainings that we have scheduled free of charge, that will be remote or online live trainings. We promised in our guidance that we would provide at least quarterly training. We are finding that there's a lot of demand for it. Our first training that we set up for August 15th sold out in 48 hours.
Sure.
So as people are ramping up until we have more third-party providers, I believe IPIB is going to have to take a more active role in providing regular training. At the training committee, we talked about providing one over lunch and one in the evening, at least every month for a little while until we can get more third-party providers up and running.
I was just curious about that.
Can we put an equivalent place on the website? Hey, we offer free training. They're currently scheduled for such and such dates.
So we have a training, drop down. It has all of our specific trainings, links for setting up for that. It has our guidance. It has a list of the approved providers. Right now it has IASB, that's hard to say, pending. So we would continue to update that, or they will continue to update that as things come through, but it's right there in a training tab. I don't know if there's a better way to communicate that. I've also put out news releases just on our homepage, or whenever we add trainings.
Yeah, because I don't object to the association charging for their training, but I think it's nice to be able to make sure that there's an opportunity that everyone knows that there's a free training opportunity. Because if you're, you know, nervous about 706, you want to get the training done. I think there's some peace of mind there to be able to get it done immediately. But I think for the broader public, I just make sure that we are doing our part there.
Yeah, and
It sounds like we are.
yeah,
IPIB has always provided free training. There was the legislature did give some money to implement 706. They did not give an additional full position, but there is the opportunity if Charlotte deems it necessary to get some temporary staff or to hire additional help in that regard.
all right. Do I have any other further discussion, or do we have a motion and a second to approve the IASB training?
I'd move.
Second.
I move in a second. Is there any other additional comments?
I just want to say that I appreciate the school boards. They had a very quick turnaround after the guidance. I was a little delayed in getting the guidance out, so I do appreciate them resubmitting once that guidance was put in there and making sure that they had everything in there. So I do appreciate their work on that, and I recognize that there was a little delay for them in doing that. So I do appreciate that.
No, I appreciate it as well. And I will say that IASB has always been very good to coordinate with IPIB and to make sure that schools and school districts have the information. So I do appreciate everything that the school board has done as well. If no other comments, I'll call for a vote. All in favor?
Aye.
Aye. Any opposed? All right. Thank you very much. We appreciate it.
Thank you so much.
All right. You're next.
All right. Alex is going to present the advisory.
Easy. All right. So we had a request from Crystal Rink with the Astoria County Attorney's Office for an advisory opinion concerning the confidentiality of trade secrets and government request for proposal. Again, this one is a doozy. I'd be happy to answer any questions about it. I'm going to give an overview though of what so essentially the issue that was presented was they had a county RFP that was issued. They received a number of bids from different engineering companies for the implementation of a greenhouse gas reduction goals and climate change action plan to achieve certain criteria that they've laid out. They received several plans. They accepted one from a particular engineering firm. And following their acceptance, several, at least multiple of the other bidders involved in that process requested the winning company's bid. So they were asked to review, and specifically the requester, Crystal Rink, was asked to review the confidentiality trade secret statement that the company submitted. They asserted broad confidentiality for most of that project. So with the exception of the sample project that they included, they were covering things like employee information, staff fees, the experience of personnel, proprietary trade secrets, pretty broad base of coverage. So the question was, what standard of confidentiality applies to trade secrets asserted in the bids submitted in response to a government body's request for proposal? So we have a disclaimer at the first bit where, we did not ourselves view the proposal. We reviewed a briefing submitted by the county. We reviewed a briefing submitted by the engineering company, but this is not a declaratory order. This is just advisory opinion, hopefully, which would be applicable to anybody who wanted to review it for this purpose. We have 3 sections to this. First, we have an overview of trade secret confidentiality. The second section, we offer practical guidance for how government bodies could approach the issue. And then in the third section, we provide a little bit of analysis on, again, not a declaratory order, but just initial thoughts about how we'd approach it. So again, I'm going to try to be quick. It's a long one. In the first section, we talk about how confidentiality for trade secrets in the possession of the government is based on Iowa Code 22.7 subsection 3, which says, and this is the full text of it, trade secrets which are recognized and protected as such by law. So what courts have found is that this refers to Chapter 550, which is Iowa's codification of the Uniform Trade Secrets Act. The definition section in 550 provides that trade secrets must meet a few standards. They must be a type of information, including but not limited to a formula, pattern, compilation, program, device, method, secret, or process, which meets both of the following requirements. The first half of that definition, before I get to the questions of fact, the first half of that definition, whether an asserted trade secret falls within the category of information protected by 550, that's a question of law. The courts have found that it is a very broad definition for information. So just about anything can qualify. As long as it is some type of information, virtually anything that was presented within the overview that the company provided would meet that part of the definition. The second part of the definition presents 2 questions of fact, and both of those have to be met for the protections of 550 and therefore 22.73 to apply. The first of those questions of fact is whether the information derives some independent economic value from secrecy, such that keeping the information out of general knowledge protects the owner's competitive edge or advantage. The holder of the trade secret must also establish that the purported trade secret is or was unknown and not readily ascertainable to a person who would profit from its disclosure or use. So on this page, it has 3 different major court cases, each deciding 22 22.73. I won't go into detail on those, but I'm happy to answer questions about them. The gist of it is that in two of these cases, Iowa Film and US West, the court identified some considerations that independent economic value must be real. It must be based on hard facts more than hypothetical. Although in the Cisco, Iowa case, they also found that that independent economic value could be met for a very broad services contract for a university. So it's not necessarily narrow restraining criteria. The second criteria that 550 requires is that in addition to the independent economic value element, information which qualifies as a trade secret must also be the subject of efforts that are reasonable under the circumstances to maintain its secrecy. So that element requires a showing of steps taken to maintain confidentiality with emphasis on reasonableness under the circumstances according to the nature of the information itself and the context in which it is shared or disclosed by its holder. And again, we have a court case that goes into some of the considerations to determine whether those efforts were met. In the second section, again, just an overview, we say that in our interpretation, 22.73 qualifies as a broadly inclusive language exception, meaning that there is confidentiality without any sort of balancing test or qualified privilege, as long as the information is classified as a trade secret under 550. The public, of course, doesn't have any statutorily protected interest under Chapter 22 for the trade secrets of the company itself. It's only the public's interest, that is only in accessing the details of the bid for transparency in the government body's decision-making process, or once a contract is formed, in the allocations that they're making within that contract. The legislature's intent seems to be to limit the public's ability to access those public records. In the context of RFPs, it allows private companies which might otherwise be discouraged from submitting bids to pursue business with the government without the risk that doing so could compromise their competitive advantage. From the government body's perspective, protection for trade secrets means that there are more bids that are likely to be received, and also that bidders are more inclined to share confidential details to allow them to make a better decision. We have a few different areas of guidance here. There are certain, it is the responsibility of the private company to establish sufficient evidence for a finding that information qualifies as a trade secret. There are 6 key factors that were identified in a case called Cementech. There are some categories of information which are more difficult to establish trade secret protection for. This is just, again, so that anybody who is looking at this, if there was a custodian who wanted to review the law, we're providing as broad an overview as possible. We provide some guidance for best practices for RFPs. So we say that, again, that bidding companies are responsible for affirmatively requesting confidentiality for any portions of their submissions that are entitled to protection. With that in mind, we included a sample from a government body which regularly does RFPs. This is from the Department of Administrative Services. Just an example, not language that they have to use, but saying, you have to provide the request for confidentiality. The default is that anything submitted to us is going to be released to the public. Providing that notice shifts the burden for ensuring compliance with Chapter 22, at least partially, onto those private companies. And then some additional guidance for the RFP process is active. Before a winning bid is selected, we have a different advisory opinion which says that sealed bids are kept confidential under Iowa Code 72.3, and that closed session meetings are authorized under 21.5 before the bid is submitted. Once it is, the public has the opportunity to request access, and then they have to make this determination. If the government body doesn't have sufficient information to determine whether a given piece of information qualifies as a trade secret, they should provide an opportunity to the bidder to submit that information. That means both that the custodian has more knowledge to work off of, and that they have an opportunity to defend themselves if the government body feels that the information submitted isn't enough, and that allows them to assert those hard facts that the Supreme Court was interested in. And then lastly, where the government body disagrees with a private company after they've received all of that information, the best practice is to provide notice to the private company before releasing the record. That gives the private company an opportunity to challenge disclosure in court if they choose to, including seeking an injunction from a court under Iowa Code 22.8. And then the final section, we provide a very broad overview based on the bid that we received. So this is just preliminary analysis, not deciding anything. We say that all 5 categories described by the engineering company in its trade secret statement would appear to qualify as information for that first question that I talked about, the question of law. For the question of facts, we say that there's one category, the descriptions of proprietary approaches and work history, which is more likely to qualify as a trade secret, and we explain the reasons why. And then we also say, without making any final judgments on the merits, it would be more difficult for the company to argue for something like names, roles, experience, and contact information of employees, at least as a broad category, because first of all, whether there is independent economic value could be argued. Certainly they provide that argument. There is a competitive labor market, employees could be poached. But under the second prong, we talk about the fact that employee qualifications, this is not something that tends to be subject to reasonable steps to ensure confidentiality under the circumstances. Specifically, names, roles, experience with the company is something that somebody could include on LinkedIn, right? And unless there are those restrictions on the employees themselves to ensure confidentiality, probably that second prong isn't being met. We have a final disclaimer to say that the above analysis should only be taken as an example of relevant considerations. It's not a firm rule. These aren't categorical exceptions or confidentiality rules. Additional facts, contents of the records themselves may provide for a different outcome given the fact-specific nature. And then we close with that one last reminder that if they disagree with the bidding company, best thing to do is to give that private company a chance to challenge it or seek an injunction. I've just talked a lot, so if there's any questions about this or things that you want to know, and I did see the typo where I said chapter 500 instead of 550, but if there's any others, I'd be happy to correct.
I have a question on that very last paragraph of 8. The employee qualifications, things that are generally what we would consider public. That last sentence, cost and salary information. So is this cost to the public entity? This RFP is going to cost you a gajillion, or is it private person get paid $1 million from my private company?
So where I'm taking that from, this is something that came up in the major case on this issue.
The film?
Yes, in Iowa Film, the court noted that in interpreting their own state Freedom of Information Acts, courts and other jurisdictions have declined to accord exempts trade secret status to cost or salary information unless the UTC or UTSA requirements have been strictly met. So that's just what's being reflected here, is that to assert trade secrets for something like employee pay or the fees that are not the fees, but like the cost
Compensation.
breakdown. Yeah.
So if in the RFP, it lays out what consultant X is going to be paid based on
Okay.
this, is that the salary?
That's what courts have found is that it's harder to meet that trade secret definition, whether it's in the context of public records request or in the context of other trade secrets disputes.
It's just, but it would have to be in the
It had to
RFP.
be in the RFP. You couldn't just say, because you submit an RFP, now I'm eligible to receive salary and cost information.
That's correct. So only in the materials that are submitted to the government body. If they're in other words, just because a company contracts with the government on one project doesn't mean that the public has a general right to access all of their other records except for what is submitted in the RFP.
But if in the RFP, there is a salary notation.
Yes.
Or there is some specific cost notation, looks like it's pretty difficult to assert trade secret on that.
The guidance the courts have provided is that it would be more difficult. It's a stricter standard.
Yeah, typically, like in an RFP, you will have a labor cost component in that, and it will list the total labor amount. Now, when you break down, I don't know if this particular one, but if I remember right from my government days, with the RFP, it may list the number of employees and what job they may hold. and it may list a prevailing wage that they would pay them. But outside of that contract, when they do work that's not for the government, what they're paid is not public information. It's only what's in the bid or
Okay.
the RFP.
Okay, that makes sense.
Yeah.
Yeah, the government body wouldn't have to provide anything that wasn't, I mean, the request is for the RFP. I think the issue in this case was they were trying to say that the whole RFP was a trade secret.
Yeah, so the contents of the proposal that was submitted, it was 184 pages. Admittedly, 139 of those were just a project sample, which was released on their website, so that's not something that they started confidentially. But for the bulk of the plan, there was a 17-page conceptual plan, which included the names of consultant and primary contacts. There's an outline of personnel skills and services, which would distinguish them from their competitors. There were samples of comparable past projects, earliest date for availability, a proposed fee structure. There was a detailed technical approach and proposed schedule, a integrity and compliance policy statement, 16-page list of resumes for key staff. And I should note it in all of this, this is just for trade secrets. It's entirely possible that other information could be covered by a different area of the code.
Like I was thinking, whatever the one is, third party, outside of government, to government, right?
22,718.
Yeah.
Sure. So this is only applying the trade secret standard, and the trade secret standard is based on that Chapter 550 trade secrets law. So it's just one-to-one mapped to, and that's the other reason why we're uncomfortable with providing more interpretation aside from just that overview of what the courts have given, because that's right on the edge of what we're able to interpret if it is that one-to-one map between something in 22 and something in another chapter.
I had a question here about the page 2, second page of the proposal or second part of the proposal.
Sorry, on the second page of the proposal. Yes. So on the second page of the proposal, they have their trade secret statement.
Right. But I mean, in here, it says that descriptions, experience, qualifications of company personnel, things like that. Is the onus on because I'm looking at this partly as the proposal itself, partly as a complaint, so I would try to understand it here. Is the onus then on the Story County to go in and check these consultants' LinkedIn profile to determine if this is publicly available information and they are allowed to, or is this something that has to be adjudicated by the courts if their RFP provider has requested trade secret status on that? Like what role does the county have in saying you have to provide this background? Because experience and qualifications of company personnel, I think it's pretty common on LinkedIn.
Sure. So one of the things that we discuss here is that government bodies are able to take the companies that they're bidding with in good faith. So if they provide those facts and say, here are the steps that we're taking to ensure confidentiality, I suppose that in that specific example, if we're talking about experience and qualifications, I think that the proper step would be to say, this is the sort of information that generally isn't confidential. Is this something that you don't allow your employees to share their information? And the guidance isn't in here. I don't think that we would expect a custodian to do that level of detective work.
Right.
The onus is on the company to provide the relevant information.
I'm just thinking about as a county person, putting up this advisory opinion and being like, okay, what are they allowed and not allowed to do?
Sure. And I am well aware that small town city attorney who's trying to do one of these bids, this is a pretty big burden. For better or for worse, it is the burden that the courts seem to imply. So just the 3 cases that I cover a little bit more in depth. There's one that was, I believe, the University of Iowa or Iowa State. I don't remember which one. They had a vending contract.
Yeah, the Cisco food contract. I remember that case.
And apparently, even though they allowed the question to go to the court, and essentially their perspective as a party to that case was let the court make the decision, tell us what to do. We don't mind releasing it if we have to.
But it was still from the court's perspective, like, yeah, we're looking for the custodian to make these determinations. The other one that I'd look at is the Iowa film case. So these were film bids. Essentially, Iowa was trying to promote cultural, these directors could come in and get people to.
Yeah, I bet you do.
And the question was, what's the standard for whether the public is entitled to access the materials submitted for those bids for public funds to go to the directors? And the court said essentially that the film companies had failed to meet their burden by providing sufficient facts to the government body, the Iowa Film Production Services Agency, whatever. The Iowa Department of Economic Development is what it was. And the question was, if they hadn't done that, could it be released? And the answer was, because they hadn't done that, they hadn't met their burden, it should be released. The custodian didn't have to make excuses for them. The onus is on the company. The custodian or their lawyer just needs to review it and take whatever statements are provided in good faith. I know my mouth is dry.
Yeah. Any other comments? Barry, are you chopping to say something here?
I have a question. I hope I didn't miss this, but Alex, in your best practices, you refer to this Form 22 request for confidentiality. Do you have a copy of that request?
It's not included with this. I could obtain one if the board is interested. The Form 22, to the best of my knowledge, is not a standard form used by every government. The Form 22 instead is a form that the Department of Administrative Services is using, which I have shamelessly borrowed from them to craft some of these recommendations for best practices because they do a lot of work.
Yeah, I'd like to see it, not necessarily for the board, but for the City of Dubuque project.
I'd be happy to pass that along. From what I saw, because I spoke with the Department of Administrative Services before completing this request. The way that form looks is essentially just a table that says, which specific pages you want to be included. What is the nature of these pages or this category of pages? What exception are you asserting? And then what's your justification for that exception applying? Whether it is something like security or whether it's student information, if it's a school contract, or whether it's trade secret. They just have to justify why they think confidentiality applies for each of those exceptions that they want to do. And then that's on their legal counsel at that point to fill out that form along with all of the other forms that they do in routine submission.
Yeah, I'd like to see a copy if you can get it to me.
I'll see if I can get it.
That'd be great.
Right now.
Yeah. Actually, Barry, Luke found it online.
Oh, muzzle top.
Let me Google that for you.
It came right up there.
Public records are amazing, aren't they?
Oh, I know. I love it.
Yeah, I found that the Form 22 was pretty elegant, pretty simple for what it needed to be. I don't know if we could include that with the advisory opinion. I don't want to, it is a public record, so we can do whatever we want with it. But I didn't want to just steal wholesale from the DAS.
I think having it in the advisory opinion, I mean, it would allow people to look at it.
We can put a link to it.
Yeah.
If somebody wants to send me the link.
So,
Yeah, I think that's a great idea.
yeah. Any other comments, questions?
Right there. Yeah, just send it to me.
If not, I will ask for a motion.
I'd move to approve the advisory opinion.
Barry and EJ, any other further discussion?
Good job.
Thank you. Very good.
Very well done.
All right, I'll call for a vote. All in favor?
Aye.
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 Any opposed? All right, thanks, Alex. Complicated. Very well done. All right, cases for the board.
All right, the first case is 24FC0120. This is Paul Dorn, Osceola County. This is one that has been before the board previously. We answered a question on the personnel file and whether that would apply to an elected official as well. We are back. It was sent for further review of the confidential information that had been submitted to the media to review, but no article or anything had been reviewed. So that is the review that was done on this coming back to you. Essentially, Mr. Doors made a request for an internal investigation file. The county said that it was confidential. During the review, there was some allegations that part of the records were provided to the media and could not now be withheld as confidential. The county agreed that the record was previously released in a confidential disclosure to an individual member of the media. They argued that disclosure did not destroy the confidentiality because it was released in an extremely limited manner off the record and was never published or released. And the custodian intended to keep the records confidential. No additional information was provided by the county after the last case or after the board reviewed this previously. There is no dispute that the record or part of the record was disclosed to a member of the media in the after record disclosure. We do have the city of Riverdale versus Dirks case in which the mayor played a video from a confrontation with an individual to a member of the media and then tried to claim confidentiality of that footage. The court said that because it had been provided, it could not be retained as confidential after that. So in looking at this with no other additional information, despite the intention of the county for the records to retain its confidentiality, that Riverdale versus Dirks precedent makes clear that that disclosure to the media by the lawful custodian would preclude them from declaring it was confidential when requested by another individual. And so because of that, we would have to follow that. With that understanding, we would have to follow that prior precedent. So with that, we do not know, we have not seen the record. We do not know what part was disclosed versus what was not disclosed. So the recommendation for this is that the county would need to provide the portion of that record that was previously disclosed to the media. And it's recommended that if they do provide that by August 1st, that the IPIB would administratively dismiss this matter at the next board meeting if it was disclosed. I know both parties, I believe, are on to provide comment to the board on this.
All right, Mr. Dorr, if you would like to speak, you can have 5 minutes. Do you see him?
I saw him log in earlier.
I did too.
He's muted.
There it is.
I see the microphone.
We can't hear you though. We have not muted you.
Mr. Dorr, would you like to speak?
If you're trying to speak, could you say something in the chat? Raise your hand.
All right. Do we have Mr. Dorr? We can't hear you at all if you are speaking. If you would like to speak, you could put something in the chat or
Okay.
All right. It might be best if you just, if you want to just put it in the chat and we can read it out so that it's retained in the record. The other option would be to call in on your phone. Just use the audio.
I mean,
It's included in the information that was sent for the link.
The agenda.
would you like me to read it out?
Yes, please.
All right, Mr. Dorr, when you're ready, that is to dial in, that is 1-855-7-529-6530. Type that out.
Okay, do you want to stick that number?
I just don't have the chat up. It's 1-857 529 6530. And I don't know if he needs.
Okay, there we go.
Wonderful.
All right. You joined?
Mr. Dorr?
We can't unmute you.
Yeah, unmute, yeah. You're showing up as muted and we can't hear you at all, Mr. Dorr.
That is the correct
*6, is that right for Zoom?
We're on Google Meet.
Oh, Google Meet, sorry.
Mr. Dorr, we do see a new phone has joined the call. Call my.
He said to pass. He'll go on without him.
Okay, all right. Do we have Osceola County here?
I believe Mr. McGowan. McGowan.
I'm James. Well, can you guys hear me?
Yes, we can. Yes. we can.
I represent Osceola County. And yeah, Nolan McGowan is here, the former county attorney. I believe he wanted to say some words. I didn't have much to add to the context of anything. Appreciate the work from Erica, and I did not realize this is her last day either. So I wanted to say, thanks for always being easy to work with in the past. But as for the recommendation, I think there's been an outstanding disagreement over whether this is a public record or not. I believe Mr. McGowan had more context to add to that, but for the recommendation itself, I think the county would probably be okay with this at the end of the day, but I know Mr. McGowan wanted to add more and had more context to add.
Great, thank you. Board comments?
Let
Mr.
the other attorney McGowan.
Oh, yes, I'm sorry. Yeah, go ahead.
Thank you. My name is Nolan McGowan. I'm the former Osceola County attorney. I was the county attorney at the time of this records request. It also identifies a record that is alleged to pertain to me. I would join Mr. Theobald in congratulating Erica on her last day. She and I had the opportunity to work together several times on other matters when I was county attorney, and I appreciated her work as well. That being said, the record Mr. Ardor is requesting is a record pertaining to the browsing history of the county attorney's computer during a specified date and time range. I would be that county attorney. However, the record that is at issue here is not a record of my browsing history on a work computer. It represents data inadvertently collected by a work network device of some kind from a non-work device whose origin is unclear. So Mr. Dorr's request does not identify the record at issue here. So it's not responsive to that request. This can be verified by contacting via further investigation, the Osceola County Sheriff's Office, Premier Network Solutions, the IT provider for Osceola County, as well as the outside counsel that previously investigated this matter when it originally came up several years ago. I also note that there was some informal investigation of a complaint that either Mr. Dorr or Mr. Jones made in this matter that was investigated by IPIP. So there is further information out there that the board should consider before ordering or making any settlement final with respect to the release of this record. He was requesting information pertaining to browsing on a work computer. There were allegations made that I had improperly used a work computer. The records that were identified never identified any improper use of a work computer. Instead, there was data that was inadvertently collected that makes up the record that is at issue here. And these statements that I've made can be verified by talking to the people who investigated this matter originally. I'd also note that it's not clear that the lawful custodian of this record released it. While I did provide this record in a limited fashion previously, it is alleged, apparently, that the Osceola County auditor was the one who released this record and that the auditor was the lawful custodian of this record. I don't believe that necessarily to be the case. And so I think there needs to be, again, further investigation into this to determine whether or not this request properly identifies the record, whether the lawful custodian who was lawfully in possession of it released it. And I would also note that this matter was previously part of an ethics complaint to the Attorney Disciplinary Board where I was investigated for this and cleared of any wrongdoing. And because this record was used as the genesis of part of an attorney disciplinary complaint, I believe there also may be grounds that this could be a confidential record or could be a record not subject to release under that provision of Iowa Code in the open records law with respect to confidential documents, as well as the disciplinary rules that pertain to confidential attorney disciplinary investigations. So I would respectfully request that the board at this time engage in further investigation of this record and whether or not it's been properly identified, whether a lawful custodian released it, and whether or not it's confidential for some other reason. So that would be kind of the background and the context I would provide to the board, and would just basically say, this isn't a public record. It's not a public record for a number of reasons. And Mr. Dorr is not even actually asking for something that exists because there isn't a record in the possession of Osceola County, to my knowledge, that relates to either my browsing history during a specified date and time range, or to what I did on a work computer during a specified date and time range. So I think that further investigation needs to be had on this matter, and that would be my comment to the board. Thank you for your time.
Thank you. All right, board comments.
What was so Osceola County did a investigation and this request is for the investigative file, right?
It's for, portions of the investigative file. The original complaint was that, because there is an advisory opinion about whether or not a county attorney can have if their investigation would be confidential, and we said that it was. So we originally looked at that. From that, the request was that, or there were allegations that part of that file had been shared with the media. There's in the response from the county, there was no real dispute about that. I will say that there has not really been an argument that this is not either from my understanding from Mr. McGowan's comments, this is either not a public record because it is not related to his work as a county attorney, or that it's the request made does not, this record that was previously potentially previously disclosed was not does not align with what that request is. That is not something that was investigated in this. Went with what the comments were made. No additional comments were provided. No written comments were provided after the last meeting. But, you know, if there are, it does sound like there are additional questions that have been raised that perhaps would be appropriate for further review if the board wants to go that direction.
But end of the day,
Yeah, if
it doesn't matter if this is confidential 10 ways to Sunday. If I call Joel and I say, hey, media, don't tell anyone, but blah, blah, blah. I mean, I like Joel, but there is no such thing as off the record
Yeah. that's-
Right.
for government.
Whatever's been shared is shared.
And the other part of it is, if it's your record, you're the custodian of the record and you do that, that's been released.
Mhm.
So, yeah,
So, I mean, I appreciate maybe disciplinary is confidential and maybe it would be confidential when it was created or anything else, but that confidentiality is lost
lost when it's.
when it's disclosed.
It's-
Well, I would have an off the record conversation with you.
I don't agree.
So, I mean, we do, IFIP does not have a copy of that record. They've not requested it. So it's, you know, the recommendation is that whatever was disclosed, and I do not know if all or portions of it were disclosed to the media. So providing that portion that has been disclosed would be, the recommendation. And if they do that by August 1, then at the next board meeting, the board dismiss this.
I'd motion that.
All right,
The entire portion of the record that was shared with the media should be turned over to Mr. Dorr.
Second.
we have a motion and a second. Any further discussion of the board?
I abstain from this.
Hearing none, I will call for a vote. All in favor of the recommendation?
Aye.
Aye. 7 with 1 abstention. All right, thank you very much for your time, gentlemen.
So Kevin, you and I can talk about how to follow up on that.
Charlotte.
I mean,
Sure. Z names are hard.
I keep looking at you. Like, why are you staring at me? I know.
It's okay.
I get Christine a lot. Very different names.
I'm sorry, Charlotte. See, if you had a little thingy, if Kim had made you one of these, then I would know who you are. I'm just gonna blame it on Kim until I can. Just pile it on, guys. Got a short window to do it.
Want to stay?
All right, the next status report is going to be provided by Kim. We're trying to spread the wealth today, for everyone.
So this is complaint number 25FC0027. This is a status report. And there was a lot of discussion amongst board members the first time this came up. And I believe there will be discussion this time. So I'm going to slow walk through this one just to make sure everybody understands what happened here and what the recommendation is of staff. So this was a complaint that was filed on March 12th, 2025. It alleged the Keokuk Police Department violated Iowa Code Chapter 22. It was accepted on April 17th. And then there was a discussion at the May 15th board meeting. And this is where the board said, we want to direct this back to informal resolution. This is kind of a big issue for us to wrap our arms around. See if you can resolve this informally. So we worked on that. We were unable to find a resolution. So it's coming back to you. So let's just take a minute here and I'm going to walk you through the facts and the analysis and the reason why IPIB staff is going to make the recommendation that we're recommending. So on March 3rd, Hamilton, who's the complainant, requested body camera footage from the Keokuk Police Department related to a charge for driving under the influence and possession of marijuana. Now, the information that we have about this actually comes from the department, and this incident occurred on February 28th. So I think part of the discussion last time was this was a February 28th incident and a March 3rd request. Now, since then, there has been significant time that has passed. This report still has not been released, but that was part of the discussion initially. What's important here is that this resulted in the arrest of the Keokuk city administrator, who's no longer the city administrator, but this was the Keokuk city administrator, so a high profile arrest for driving under the influence and possession of marijuana. And this is now going to trial. So this has been out in the public, Keokuk city administrator, high profile position going to trial. So got to give the department credit here. They did apply the applicable balancing test for releasing a peace officer investigative report. So we're very happy to see that they applied the balancing test. We don't think it was applied in the same way that IPIB would apply it. But this is the conclusion from the police department. They concluded the footage is part of a peace officer investigative report, and it includes the presence of a named but innocent suspect. And then I'm going to quote here what the department said. The suspect is a named but innocent suspect in an ongoing matter. The suspect has been charged, but his case has not been adjudicated by the courts. So at this time, the suspect is a named but innocent suspect until proven otherwise through adjudication by the courts. They also said the Keokuk Police Department believes releasing this footage may taint a jury pool, making it difficult for the suspect to receive a fair and impartial trial, particularly if the video or portions of the video are successfully suppressed and not entered into trial as evidence. So their position was named but innocent suspect could taint the jury pool and make this difficult to try the case. Now, Hamilton has said the courts have ruled on this concept of a named but innocent suspect and tainting the jury pool, and that the report should be released as a public record pursuant to Chapter 22. That's where we were at when we brought this to the board. The board said, please take this back to both parties. This is a big issue. See if you can work this out. Went back. We discussed it, and Keokuk Police Department has maintained the position that the report should not be released until the conclusion of the trial. So we took another look at this, and our recommendation is going to be the same, and that is that the report, and actually it's the body camera footage, should be released. So I'm going to walk you through why we came to this conclusion. So as you know, Iowa Code 22.7 creates confidentiality for certain types of public records. Peace officer investigative reports, no doubt, fall within 22.7. But there's always been case law on this that says it's a qualified confidentiality. So they have to show that that peace officer investigative report should continue to be protected as confidential. So it's not automatic, it's qualified. And then over litigation that has occurred and what seems qualified over the years, there have been a couple landmark cases that have come out. One is Mitchell versus City of Cedar Rapids, and the other is Hawkeye versus Jackson. And those two cases were instrumental in creating this, okay, you're going to apply a balancing test and you're going to determine whether this should actually be preserved as confidential or not. So you can see here we cite to Mitchell, which is that, again, it's cementing this as a qualified rather than categorical privilege. And in Mitchell, this was a civil case, but Mitchell was shot by a police officer during a traffic stop and filed a civil case. The district court allowed the release of the reports because the investigation was complete. There were no confidential informants used. Then this was appealed up to the Supreme Court. The Supreme Court said that they agreed that they should be released. But I think what I really want to point out here is that in Mitchell, the argument was made that the report release could taint a jury pool. So very, very similar argument that we're hearing in Mitchell. The court disagreed with that premise, and they said, we believe that concern, so the tainting of the jury pool, can be addressed during jury selection. And then they cite to the district court and say, the alleged facts of this incident have been the subject of wide media coverage and broad public discussion. This is a county of over 200,000 people. They said that, and that this should not jeopardize any party's right to a fair trial. They also said attorneys need to comply with the Iowa Rules of Professional Conduct, which prohibits an attorney from making extrajudicial statements that will impact the trial. So they're saying there are a few different ways we're going to work through this tainting of a jury pool. One of those is picking your jury pool and using the rules of professional conduct for lawyers. So want to point out that Mitchell did address that. Then we look at Hawkeye versus Jackson, which is the other landmark case in release of peace officer investigative reports. And this was possible excessive use of force by the police department was the underlying issue here. Again, the district court said the peace officer investigative report should be released, and they said any harm to the public interest caused by disclosure outweighs the public interest. And they said, we want you to go ahead and release this. It went to the Iowa Supreme Court. Just like Mitchell, the Supreme Court said we want it released. These were the reasons why. There were no confidential witnesses. The investigation was closed. The report did not contain hearsay, rumor, or libel of any kind. And then they cited to the important public interest of ensuring a police officer cover-up did not occur. And you'll hear in this particular case, that's part of this too. You have a city administrator who's working closely with local police, want to make sure there's not any kind of cover-up or things happening here that shouldn't be happening. So we looked at Hawkeye and we looked at Mitchell. And we said the investigation is closed. The report does not contain a confidential or unidentified suspect. The suspect is out in the world as the suspect. They've been publicly identified. And the individual arrested and charged was the public administrator for the city, worked closely with the department. There's a public interest in ensuring the case was processed without conflict of interest or cover up. Those were the main considerations that we looked at when applying the balancing test. So what we have said is that we believe that applying the balancing test, it should be released. And if you look at the last page, there are a whole series of criteria that we looked at. The investigation is closed, no confidential or unidentified suspect. The request is for body camera footage recorded on a street in a public space. The individual arrested and charged is the public administrator for the city. So making sure there's no conflict of interest or cover up. Primary justification for confidentiality advanced by the department was the innocence of the suspect until proven guilty. That's clearly been addressed by the Mitchell case. If the department's interpretation is applied, Iowa Supreme Court precedent creating a balancing test before establishing a qualified privilege of confidentiality would really never apply until the conclusion of trial. And then there is a public interest in the body camera footage that outweighs any minimal privacy interest in this case. So these were the criteria that we applied. We looked exclusively just at Chapter 22, and our recommendation is that the footage should be released. I want to point out that the complainant could not be here in person today. He did provide comments. Those are attached in your board packet right after the proposed status report. I do believe counsel for the Keokuk Police Department is on the line and may have some additional thoughts here too. And then with that, I know there will be discussion on this. And so I will leave that in this board's very capable hands to determine how best to address this. So we'll pause there.
You looking for the comments?
Right here. Very good. All right. So Mr. Hamilton has released comments. Do we have anybody from the Keokuk Police Department that would like to speak?
Hi, this is Holly Corkery from Lynch Dallas. I represent the Keokuk Police Department.
Holly, is there anything that you would like to say?
Yeah, I do have a few comments. I think it's important when you're looking to Mitchell for one, and Kim pointed this out in her comments, but Mitchell was a civil case involving a discovery dispute that discussed open records. And those records were analyzed as part of that discovery argument, but the court wasn't talking about evidence in a criminal matter being put out for public consumption before the accused goes to trial. And I think that's an important point to make. And I know one of the concerns the board was discussing last time you met was just how county attorneys, process information and put their case up, and how they're able to do that through that process. And if all of that is going to be public now, I think that's going to be very difficult for police departments to maintain that relationship with county attorneys' offices. And I think it's going to make prosecution very difficult on those offices. The other thing I'd like to point out is the specific language is a little bit different than what was identified at the end of the Savage report. The city relied on the named but innocent suspects language, and I think at the end of the status report, it's identified as innocence of the suspect until proven guilty. But in the balancing test, that named but innocent suspects language, that was used in Mitchell. It was used in Hawkeye versus Burlington. This board cited to it in a January advisory opinion from this year, which the police department relied on when making their decision. And I'm not sure what that language means if it wouldn't apply here, right? We have a named but innocent suspect until he is prosecuted through the system, and then we don't know what will happen at the end of that. So I don't know if that language is ultimately rendered useless. And I understand you have to balance that as part of the balancing test, but I do want to point that out. The city has told Mr. Hamilton, and we have been forthright, that when the prosecution is over and the case is concluded, if Mr. Hamilton wants to make a request again, we would analyze that at that time. We would balance it again and then produce the records if it would be appropriate at that time. So this isn't a, you're never going to get these records. It's a not now. And that was the message conveyed to him in the initial letter. And then the last thing I would just like to say, thank you for listening to me as I've gone on. But the last thing I would like to say is that the department did apply the test here and really went out of their way to, even before they talked to me, to make sure that they were understanding the law and trying to follow and do the right thing. They had looked to that advisory opinion of the IPIB. So if you were going to make some order, I would ask that you not find probable cause. And if you're going to order that the records are released, you know, I understand that, but I'd ask that you not find that there be probable cause of a violation against the department, because here they weighed, they just weighed it subjectively different than you would.
Thank you. All right, board discussion.
You want me to go first?
Go ahead.
To no one's surprise, I gave Kim a heads up that this one is a hard no for me. What the Keokuk PD did is consistent with every single police department in the entire state. You have a constitutional right that you're presumed innocence, and you have a constitutional right to have your one fair trial. So by adding this, we're getting our 2 trials and our media trial, and then our fair trial. I think there's 2 main points I want to make. The first is that allowing this information through public records completely guts our rules of criminal procedure. There are rule 2.14 for indictables and 2.64 for simple misdemeanors, and that is how the defendant gets the material. So if this was just a simple misdemeanor, a traffic, that person has to go to the prosecutor and say, dear prosecutor, more than 7 days before trial, I want to see the traffic video. That's the only way that person gets that video. If that person who got pulled over for speeding calls my office and says, I want that video, and they say, you have to go through criminal procedure. So this would put the general public at a higher advantage than our criminal defendant, because I'm not releasing it to the criminal defendant. I'm going to release it to the prosecutor who's going to give it. Same with indictables. The prosecutors don't necessarily legally have to give everything in their file to the criminal. Sorry, I'm sorry. That the prosecutor has legal standards on what they have to provide and not provide. So in this case, yes, he's going to get the video, the defendant is, but he wouldn't have got it 3 days after he got it arrested. And in this specific case, he has a motion to compel set in a couple months from now. So the media is going to know, the media is going to get this video during the motion to compel. It's just whether they're going to get it now before it's been made public to the court. The other thing on this too is it depends, is the court has the ability to do discretionary discovery orders and discretionary protective orders, where the court can even say, you defendant get this, but it can't be disseminated beyond the defendant or beyond the defendant and the defendant's attorney. So, you know, it says, you know, this would gut the balancing test pre-trial. Well, our rules of criminal procedure already gutted. You know, our written statutory accepted by the legislature rules are already contrary to this balancing test pre-trial. Post-trial is a whole different, you know, whatever you want to do post-trial is that. The other thing, I have a love-hate relationship with Mitchell. Because Mitchell is a good example of bad facts make bad case law. Because if Mitchell had been a straight Chapter 22 request, we would be in a lot different Oh, then the weird, it was a civil case years later, which is, I think that's a huge factor here, is the Mitchell video was way, way later. And I think the jury pool argument is also balanced in favor of Keokuk here too. Because I put it, well, I didn't know Keokuk is not in Keokuk County.
No,
It's not.
Lee County,
Keokuk County has like 9,000 people. Lee County has
a lot less.
a lot less, 22. Lee County has 32,000 people. So that's a tenth of what our jury pool in for Mitchell would have been. And I think that, again, if you haven't picked a jury in a small county, like, it's not a fun process. The other like icky part that just is not sitting to me is that because he's a public official, he gets tried in the public. Whereas if I just requested Drunk Bob's OWI, I'm going to say, ooh, there's not the right cover up and things like that because it's just Drunk Bob. So Drunk Bob's is not public, but you know, somebody else's is.
I'm torn with this one. If the case were over, it would be different, release it.
Right.
But that, I mean, and yes, public official should be released. We had a very similar situation in Jackson County that ended up going to court that started in Clinton County with a public official. But this one, yeah, I really think it should be released, but it bothers me that the trial has not been held. And I always wondered, I thought you didn't use innocent for anything. I thought you used not guilty, or is it presumed, should it be presumed innocent? I don't know. But
Yeah,
it should be released, but it concerns me that they want it released prior to the trial.
Yeah.
And I'm not a lawyer, but I mean, that does kind of bother me because, yeah.
The other thing that just rubs me wrong a little bit too is the conduct, the video in Mitchell was the officer's actions as an officer. You know, he was acting as a cop when he shot whoever, Mr.
Yeah.
whatever his name is, Mr. City Administrator, I'm assuming was not acting as a city administrator when he drove drunk.
I would assume he would not have been.
So it's also his private conduct that is caught on video. It's not showing up at a board meeting drunk.
But if we followed the line of thinking, even if he showed up drunk, you couldn't show the video because he would have to go through his trial for public intox.
But
So
that's in a public setting. I mean, this is
outside
This is
in a
out-
public setting.
This is outside of a public setting, but yes, he was a public official when it happened. He or she, I don't know whether, you know, I'm assuming he. But the Mitchell case drove the IPIB crazy when, I mean, and I mean, we've had several video cases in front of the board. And my concern with it is, like I said, it needs to be released. Concerns me that trial is not over. That's my hang up with saying release the tape.
What if this wasn't is Hamilton the city administrator? Hamilton's just.
No, Hamilton's a citizen.
He's a citizen that,
But what if it was Hamilton requesting his own video that wasn't charged?
that's different because he's,
Right.
yeah, because he's acting as the public requesting, requesting this video.
If he was the defendant, if Mr. Hamilton was the drunk driver, we would say go through the rules of criminal procedure. Right. Have the
And
right to the
you
materials.
laid it out. What if it was, I just got pulled over for a speeding ticket and I want the footage of that? How does that?
Rule 2.64
Right.
says you have to ask the prosecutor.
Right. And then they have discretion about whether they
No.
provide it?
Not in 2.6, no.
They just have to turn it over.
Yes.
Do you? Yeah.
Yeah, to me, it's involved.
You have to ask 7 days before your trial.
Well, I'm not charged. I got off of the warning. I want to see the video of the interaction.
There's nothing pending,
Yeah, there's nothing pending.
then you could, in theory, ask the PD for it
And they do the balancing test.
and they balancing test you.
Right, and they would say the investigation's pending, open, close. I mean, I think that's my thing on this. I feel like there's a lot of the stuff that Kim laid out, I think is pretty compelling for me. Taking into account everything you said, the investigation is closed, right? This is a done deal. And so whether we're letting it out 2 weeks before the trial, I mean, frankly, and nothing too disparaging to Lee County, but no one's running CNN down there. There's not a CNN outlet. This is like a local media place. And I think that there's a component of this, right, because he's a public person, acting privately, but still representing the public or doing a public job. I mean, I think there is a compelling case here to say, putting aside the video, I want to know as a voter and as a constituent and as a resident that the people that I have working for me are acting completely responsible. That's the part that I think is important, because I want to know that even if the sheriff is doing it after hours, drinking and driving, that's important for me to be able to know, and you can charge them all day long.
I do not disagree with you. We had an assistant county attorney
Mhm.
who was pulled over in Clinton County because the ex-boyfriend in the car called the police. And the assistant county attorney, because she prosecuted drunk driving cases, followed her own advice and was charged with an open container rather than OWI. They did not allow her to drive, but they drove her to the courthouse where she spent the night publicly intoxicated in her office. And officers lied about where they were at and whether their body cam was on. The videotape was inadvertently deleted and had to be brought back in a court case. And there were some very troubling facts in it. The prosecution part was done because they were only charged with an open container, a fine was paid, and it was done. When the media heard about it, they requested the file, and lo and behold, it was a challenge. And so after the court got a hold of it, it had to be released. And I don't dispute that this should be released, but even in that case in our county, the case was completed.
Right.
And then it was released. And that's my concern here, is that the case has not been completed. And I really believe that it should be released, but it does concern me that this is not adjudicated.
I appreciate your argument on Mitchell, but how do you get around Hawkeye? I mean, doesn't Hawkeye compel us to release the tape?
I think that the component of Hawkeye that's probably the most compelling is weighing the public interest versus the private interest. And in this case, I'm not sure what's left of the private interest. That's, I think, the IPIB staff's position. There's really nothing there left to protect. And the public interest here is making sure that this was conducted appropriately.
See, I disagree, because I think the public,
But Hawkeye and Mitchell were civil suits. This is not a civil suit.
and I think the public interest is trusting that the justice system is going to work, and you will have a jury of your peers. And that's the public interest to me, is that we will let facts shake out before that. I think that's a stronger public interest than craning your neck at an accident that goes by.
I would appreciate that, but as a matter of law, doesn't Hawkeye again compel us to release the tape?
So in both Hawkeye and Mitchell, they talk about an ongoing investigation. They do not bring up a suit. In Hawkeye, after DCI did their investigation, they chose not to prosecute.
And just because it's done, there's this line in Mitchell that says, even if the investigation is complete, it doesn't get rid of the confidentiality.
The qualified confidentiality, you
Qualified
still have to do the Hawkeye.
So you do
balancing.
That's what required us to do the balancing test, was Hawkeye, because we had not done a balancing test prior to that. And when that came out, when the Mitchell case came out, is when we had to do the balancing test, which
Keokuk did here. Keokuk would know its community better than us.
I'm having a very difficult time with this because I think all of these arguments are very compelling, but I'm also back to the spot where I think that we have the ability to release this. I also think there's a responsibility in part of the legislature that if they don't want, we've gone through this process and we find it, we're tilting halfway towards releasing and your legitimate concerns of really like putting in a bad spot our criminal system. I think that's a problem for the legislature, not for necessarily for IPIB in this case.
Well,
I
the
mean-
legislature approves the rules of criminal procedure and adopts them. So they've already outlined when stuff gets released pre-trial. So for us doing this, we're ignoring
The legislature says it, right? The criminal procedure rules are
written by the
judicial
court and
branch.
adopted by the
The
legislature.
legislature, like every other rule, signs off on it. The judicial branch writes the rules.
Well, and then 2.64, the simple misdemeanor discovery is new. They've just been doing that the last few years and that was hotly talked about up there, whether they were going to approve it or not, because it increased PD's workload so much to get evidence out the door. So this is not that they haven't thought about when
No,
this stuff
certainly,
goes.
I know.
The
I know they thought
legislature
about it.
has, and they told us how to do it.
I don't know.
I think we have two different interests here. The problem is that our focus is on chapter 22. I mean, that's kind of where we
Yeah.
are. I mean, the investigation,
The investigation
the
is
police
over.
investigation is over. But whether it's open or closed, that's part of the balancing test.
We can also table this 2 months until he has his motion to suppress hearing and then they'll get it anyway. We're making what I think is a very big decision. Because even like in my volunteer work, I opened records request Des Moines PD for body cam footage last week. And their system was wrong. They said this person hasn't pled guilty yet. You have to wait. And then I showed them, no, here's Iowa courts, they pled guilty. And then they're charging me $30 or whatever.
Right, yeah.
So I don't want to say like just DPS does it this way and we do everything right. Like nobody's giving it pre-trial.
What about anyone online?
Barry?
Bueller?
I don't know. I have a lot of trouble with this, but as I read Kim's list of factors that she considered, I tend to agree with her that the bottom line is in favor of releasing the documents. When I consider all of those factors. In addition to that, the point was made, I'm not sure who made it, but this was the city manager not acting in his official capacity. I mean, seems to me that's significant here as well.
Significant.
To justify releasing the information.
In favor of releasing?
Yeah, I mean, I would add that to Kim's list.
I have the same problem. I think we're all wrestling with this probably equally. I think the point, for me, the problem is the issue, your point you make, I think, Catherine, about the jury pool, I hadn't quite dwelled on it the same manner, but I understand, appreciate your input. The problem I have is, on the one hand, we're talking about a public official. And if it had been, as you say, Joe drunk or EJ drunk, but then it had been entirely different. But as someone who's been in the public sector, I just think that when you do that, you accept a higher standard.
Yeah.
And it's easy to say, well, if he were Joe Schmo, we wouldn't be talking about this. I get that. He made this person, where I don't know, I suppose it's a guy, but anyway, this person made an open decision to take on the public trust of being a city manager, city administrator. So I don't think it's unreasonable to hold him to a higher standard. Not that it's relevant, but I remember I had a chief of police that wouldn't drink in Urbandale, but if he went someplace else, he might act differently.
Right.
But, so I guess I come down on the side recommendation of staff. I think you can argue legitimately there's some unfairness about that, but on the other hand, everybody knew what they were doing when it all happened. I guess that's where I come down, but I did deal tough with this because I've worked with city administrators. I know a lot about how they operate, but I just have to say that I just don't think it's unreasonable to hold them to a higher standard. And I guess so. I would come down on the part of going along with the staff, although I talked out of it. Keep talking, she'll get me because I'm very impressed with your analysis.
I mean, I think this is hopefully a unique case, although if you guys keep telling stories about public officials getting pulled over for DUI, maybe it's a bigger issue, but I think this is a unique case and it doesn't necessarily change generally. In this case, we're talking about a public figure, which in the balancing test, if we're talking about a balancing test, it moves in favor greatly toward the public having a right to know. The investigation itself is over. The language in Hawkeye and Mitchell both talk about investigations. They don't talk about trial. And again, we're not talking about Joe Schmo from off the street. I think that would be way more in favor of, less public, public interest over privacy. But,
my concern with this, and I see where the staff is coming from, but here's my concern. I live in a very rural county. And if we say, okay, let's release, to be perfectly honest, I can see more public officials being let go just so that, the county attorney and the sheriff's department doesn't have to think about releasing any video footage.
Oh, like when they're pulled over.
Right.
What if this individual was pulled over and not charged? And then the video was released and then the county attorney is then compelled to charge them or finds that they should have charged them. I think.
Oh, that's not what happens when we saw, should have been an OWI.
Right.
And instead it was an open container because this attorney had prosecuted OWI cases.
Totally get that.
And so it was all swept under the rug and then it came out and people were mad.
Yeah. No, and they should be, I think.
Right.
And that's kind of where I'm at too, is I'm trying to think about this in the way that what if we didn't, what if this was a request of the county attorney that hasn't already been known, it wasn't at trial, the investigation's closed or whatever. What if there wasn't an investigation like, hey, you gotta get out of here, like this is no good. Someone requested the video, then it came, it's the same outcome because the trial hasn't started yet or hasn't concluded. The charge is now filed because of the release of the video. And I hate to even get into a hypothetical here, but I'm trying to get to a place where I think it's where I get to a much firmer spot here, whether we're talking about just chapter 22 and 21, frankly, for IPIB, or if we're trying to account for criminal side of this as well. I think because if I'm releasing a video that no one else knew and suddenly there's outrage about it, then I think that pushes your hand to do something about it.
I honestly think there's conflict because 22 compels us and the statutes compels us to release it.
Right.
End of story.
Right.
On the other side of it is the prosecution where they have their rules as well that says don't. So it's one of those where we have to look at it as a board on what's there. And like I said, I'm torn on this one. But what we have to follow with chapter 22, we should release. And I think I'm sure it's going to go further. But I am torn because it's one of those where the criminal case is not complete.
Do we not have the option to table since it's not complete?
Oh, we can, yeah, we can table. We don't have a motion out there on either approving, to approve or to table this. I mean, this is just kind of a,
I probably shouldn't, but I'm going to speak to the issue of table, and I guess table is a mechanism from my point of view that there's something else to be done. And I don't think in this case, anything's going to change in 30 days or 60 days or whatever. So I would say that we should make a decision for multiple reasons, but that would be my position.
This is the downfall of the new process working so much faster.
Yes.
Because under the old system, this case would have long gone to
2 years
trial.
from now, yeah.
We may not have been on the board anymore.
Right.
Well,
we can
you know,
blame
that's why you
Erica.
guys have a new director.
I agree with EJ. I think tabling is just, that's bad precedent for the board. I mean, we could table every case we get if there hasn't been a trial yet. And I think we're just abdicating our responsibility.
I'd call the question.
Yeah, I did like Holly's comment on the not finding probable cause for this leasing. Is that a more nuanced?
So, I mean, what you could recommend is that similar to what we did with the door case, if they release it by a certain amount of time, then on August 21, you'll dismiss it. Or you could say we'll dismiss it if they agree to release it, or I mean, you don't have to find probable cause. And I agree with Holly that they did do the balancing test, you know, and that's what they're required to do. And we did come to a different conclusion than they did. So I could see that. You guys could choose to, if you dismiss it, then you kind of lose jurisdiction. So it depends on if you want to hang on to it to have it released, if you want to get promises from, I don't know. So I guess that's the only problem with just if you chose to dismiss it today, unless you had like, we'll dismiss it on August 21 if something's released, if that's what you want to decide.
Without a case of Holly's comment about without finding probable cause, but
Correct.
dismiss without probable cause.
Right, but if you if you dismiss
Oh, I see what you're saying. I'm
today,
sorry. Yes.
they haven't released the video, so we don't have jurisdiction anymore. That's my only, I mean. So it would be similar if you found probable cause, but I would agree, she's make a good argument that they did do the balancing test. There shouldn't be probable cause just because we come to, I mean, look at how much we're arguing about it.
Right.
We got to make a decision, either release it or not.
so I will call for motion. Does anybody want to make a motion on this case in a second?
I would move to release as recommended by the staff.
We had a date by such and such date to help staff here.
So.
I would say August 8th or August 15th. 15's cutting it close, but August 8th.
Yeah, I mean, if the next board meeting is the 21st, so if you wanted to do a status report at that point, or if you.
Say August 15th.
And that's fine. What the next one?
21st.
All right, I'll go with those. Motion is to release it. It's good.
And if they do, then there'll be a dismissal.
Okay, so I have a motion made by EJ to release the video by August 15th. And if it is released, we will dismiss it at the next board meeting.
I'll second that.
Okay.
I'd suggest.
I want a roll call vote.
Ask for a roll call vote.
Yes, I would like a roll call vote.
Joan Corbin,
Aye.
EJ Giovanetti,
Aye.
Mary Lindahl,
Aye.
Catherine Lucas,
No.
Luke Martz,
Yay.
Joel McCray,
Aye.
Monica McHugh,
Put me last.
Jackie Schmelling,
Aye.
and Monica McHugh.
Can you cut me in half? I'm gonna vote no on this one.
So the vote is 6 ayes, 2 nays. It passes.
It's not a pretty one. I really do.
All right, next case.
All right, this one should be, it's gonna be the longest board meeting I've had since I started here.
This was my only highlighted one, was the one we just did, so.
All right.
What a chair.
All right, so this is
Did I have
Cody
more?
Edwards and Iowa Department of Revenue, case number 25FC0049. In this case, Mr. Edwards filed the complaint alleging a violation of chapter 22. Oh, I'm sorry, that got removed because we did not get assigned. Yeah, oh, okay, sorry, I thought you guys, no, I
printed it
we
out
didn't
before.
feel comfortable putting it in there when we didn't have it signed yet. Okay, sorry.
I sit by every Friday.
I know, and that's why I tell you what I changed in Tuesdays.
I just wish you'd tell me on Saturday.
Well, talk to the new director. You can lodge your complaints there. This complaint started with a contested case proceeding between a company and the department. The contested case was appealed and reheard by the department. It's now being appealed to the district court. There's a hearing on August 1st. The contested case and the corresponding litigation is outside our jurisdiction, just so everybody knows. In the midst of the proceedings, Edwards did make a public records request to the department on behalf of his client. There were a series of communications regarding the scope of the request, as you can see in the investigative report. Eventually on April 17th, the department did provide documents in response to the public records request as it was finally determined what would be requested. It included 142 emails and other documents. They stated other records were withheld based on attorney-client privilege, attorney work product, and or the draft exception under Iowa Code Section 22.7. Mr. Edwards requested a listing and a description of the communications and documents that the department identified as being exempt from disclosure under that confidentiality. The department did decline to provide a listing and description of the records withheld. This complaint then was filed, and Mr. Edwards seeks 2 forms of relief: a clear justification for withholding each record deemed confidential, essentially creating a log of what is being withheld, and the release of public records that are not in the form of emails from July 2022 to the present, which is stated was not part of the communication of email, of restrictions of emails specifically. So looking at these 2 issues, essentially the first one, justification for withholding each record. Mr. Edwards argues the department has a burden of proof to demonstrate justification for withholding a public record as confidential, and that there should be some kind of privilege log with those records. The department, he cites to the Kirkwood Institute versus Sand case for that purpose. The department provides the following arguments in support of its position that it does not have to provide a privilege log for those confidential documents. The doctrine of attorney-client privilege is outside the realm of Iowa Code Chapter 22. Chapter 22 does not require the production of a privilege log or the release of records that are attorney-client work product, and that IPIB has a history of precedent that supports that attorney-client privilege exists outside. It's also noted that the attorney-client privilege has not been waived by the department in this regard. IPIB does have a history of to support that attorney-client privilege is reviewed outside of Chapter 22. And there is nothing within Iowa Code Chapter 22 or any other statute within our jurisdiction that requires the disclosure of a log or other detailed information to justify the use of an attorney-client privilege or attorney work product exception. The department has invoked its attorney-client privilege as it relates to these public records, and until there is a requirement under Chapter 22, there's nothing that requires the department to provide additional information to support that justification. In regards to the second issue, Mr. Edwards brings up a release of additional records. IPIB staff finds that there was a legitimate confusion regarding the scope of that original request with the communications and recommends that that information, additional information, if any, that exists, be provided to Mr. Edwards within 30 days. As far as discovery process, there is an appeal pending in district court, and this order is only based on our jurisdiction related to Iowa Codes Chapter 22 and 23, and does not relate to any discovery matters that emerge in the litigation between those two. Based on this, it's recommended the matter be dismissed for lack of probable cause believe a violation has occurred. Department is directed to release any additional public records related to the communications that were part of the confusion regarding the scope of non-emails, but there is no need to provide a privilege log regarding the attorney-client communications. Mr. Edwards did provide a extensive communication on his position there. The department did respond to that this morning. There is a copy over there, but it was not received in time to our deadline for the packet. And I believe both parties are here to discuss this with the board.
All right, Mr. Edwards, we can give you 5 minutes if you'd like to discuss.
Yeah, thank you very much. Can you hear me?
Yes, we can. Thank you.
Okay, so I first want to be clear what we're seeking here. We're not seeking a privilege log per se. We're seeking justification for the Department of Revenue withholding each of these emails. They've claimed attorney-client privilege. There also seems to be, and I don't know if the Public Information Board overlooked this or if conflating the two concepts, the Department of Revenue also claimed attorney work product exception. And so Alex, the gentleman who was talking about the draft opinion earlier, he clearly agrees that there has to be some substantiation of why documents or public records are being withheld from the public. The Supreme Court's been very clear on that. Disclosure is the rule. The one seeking protection of the statute bears the burden of proving the exemption's applicability. I, quite frankly, do not understand how IPIB's investigative report can say that public records don't require the use of further justification, or public records that are withheld under an exception don't require any further justification. The Supreme Court hasn't made any sort of distinction between these privileges. It says if public records are withheld, the person or entity withholding them has the burden to prove the exemption. And so I don't understand how that's square. Now, Public Information Board does cite this Dirks v. Mullen case, but all that case said was that there's no privilege log procedure in place that requires a privilege log. Now, that's specifically related to a privilege log, but we're not asking for a privilege log. We're asking for the Department of Revenue to explain or provide details sufficient so that we can determine whether the information withheld actually falls within those exemptions claimed. And so this is what's going to happen if the Public Information Board allows, or if this ruling stands. It says, well, if you claim an exemption or an exception, you don't have to provide a log. What's going to happen now? Governments can say, no, I don't want to produce that video footage from the police officer because that was attorney work product. Based on the IPIB's opinion, That's the end of the inquiry. And correct me if I'm misinterpreting that, but the way the report is written, even if an exception is within chapter 22 from disclosure, additional information or justification is not required. And I point you to, it's page 5 of the investigative report. It says, and you read this, is there's nothing in Iowa Code chapter 22 or any other statute within IPIB's jurisdiction that requires the disclosure of a log or other detailed information to justify the use of attorney-client privilege, or, and this is key, attorney work product exception. Attorney work product exception is within chapter 22.2.7. And so is the trade secrets. And so if IPIB is saying, if you claim attorney work product, you don't have to provide further justification, they also must be saying that if you're claiming trade secrets, you don't have to provide further justification. And I'm saying that because both trade secret exception from disclosure and the attorney work product exception from disclosure fall within chapter 22.7. They're exceptions from disclosure. And your attorney, Alex, clearly went over the cases that said, even if a government entity or even if a private individual tries to prevent disclosure based on one of these exceptions, the person trying to prevent the exception has to explain with specificity why it's withheld. IPIB's report says otherwise. It categorically says, if you claim attorney work product exception, you don't have to provide any more justifiable details. That's it. And if that's not what that says, then I would appreciate if somebody could explain that to me. I also think there needs to be clarification from the department on whether they're claiming each and every item held from disclosure meets, or they're claiming all 3 exceptions from disclosure for each document, or if some are, for example, 10 of them are attorney-client privilege, the remainder of our attorney work product, and then draft exception applies.
Thank you, Mr. Edwards. Your time is up on that. Do I have someone from the Iowa Department of Revenue who would like to speak?
Hi, yes, this is Angela Stuneman. I'm from the Attorney General's office representing the Department of Revenue. Can you guys hear me okay?
Yes.
Okay, great. Very simply, the issue before the board today is whether the department properly withheld these emails as attorney-client privilege and attorney work product. And the answer is unequivocally, yes, it did. First, I do want to clarify that the sole universe of documents being withheld is those emails. As far as that second category where there's some confusion, we have produced everything that was responsive in those categories. We are not withholding anything in those categories. Everything that existed that was responsive has been provided. So it is just this universe of emails that we are talking about. And to be clear, nowhere does the department view the investigative report as relieving it from its burden to demonstrate the applicability of the claimed exceptions. It has met that burden. The department has explained in its briefing submitted to this board that the emails withheld were between attorneys representing the department and department staff regarding ongoing claims and litigation against the department by Lamar. The department has explained that as it was represented in that case by the Attorney General's office, the withheld emails included communications with the Assistant Attorney Generals litigating the case, communicating with the department, including Ms. Royster specifically, to obtain documents and signatures necessary for the district court filings. There was also a conflicts counsel from our office who was assigned to advise the department director in making her decision. That counsel was screened from the Assistant Attorney Generals litigating the case, and as such properly was able to communicate with the director as well as her helpers, quote unquote, Mr. Clough and Mr. Bishop. The Iowa Court of Appeals in Dierks-Mainland did recognize, as Mr. Edwards has noted, that the burden of proving an exemption does rest with the department. However, that the court in that case also suggested this was a low bar. In that case, the court cited and affirmed the proposition that there is in fact no requirement the government body must affirmatively plead an exemption to disclosure. And in that case, the court found the city failed to meet its burden specifically because there had previously been an agreement at the lower
Sending
court
a photographer.
where the city waived arguing the exemption. Therefore, it found the city could not, on appeal, change its mind and maintain an exemption. But it contrasted that to Horsfield, where in that case it noted, importantly, the city had invoked privilege as a basis for refusal, suggesting that invoking privilege did meet the burden. Here, like Horsfield, the department has invoked its attorney-client and attorney work product privileges from the beginning. Now, it's argued by Mr. Edwards that for the department to meet its burdens of showing these documents were properly withheld, the department must provide the date of the document, the personnel of the department who wrote or received the document, the subject matter of the document, and a specific basis described in narrative form with citation for withholding that document. In essence, a privilege log. I know he says it's not a privilege log. I don't know what else you call that. That's a privilege log. Yet this body, as well as the Iowa Court of Appeals and Dierks v. Malin, has made clear that a privilege log is not required. Without this information, though, Mr. Edwards insists the department is saying to just trust us, but that's far from the truth. I just explained the withheld emails and how they invoke attorney-client relationship and the work product of attorneys in the context of ongoing litigation against the department. The department has met its burden of demonstrating the applicability of both of those privileges. Yes, the purpose of the open records laws is to promote transparency, yet Chapter 22 itself carves out dozens of exceptions to disclosures, and each of those privileges arguably undermines the policy of the Open Records Act if you're Mr. Edwards. Yet the legislature saw fit to carve out those privileges because it determined the policy interest in protecting those specific types of documents was greater than the policy interest in disclosure. Here, as I've explained, the emails withheld fall squarely into one of those carved out privileges, attorney work product. Further, the Iowa Supreme Court has made clear in Horsfield v. City of Dyersville that Chapter 22, quote, does not affect other specific statutory privileges recognized by the legislature, such as attorney-client privilege. To require the department to provide the detailed information Mr. Edwards insists on, again, amounting to a privilege log, not only flouts the precedent of this body in the Court of Appeals in Dierks v. Malin, but weakens and jeopardizes the integrity of those revered privileges. Therefore, the department would respectfully request that the board affirm the recommendation expressed in its investigative report and dismiss the matter. Thank you.
All right. Board comments?
Staff have any comment in light of some of the comments that were made?
I would just say that IPIB staff do not have authority to review attorney-client privilege unless it's been waived. And we have never, in my years here, required a log of documents that have been withheld. If this were something where they were claiming that there were trade secrets, we could request those documents under our authority under 23, but we do not have that authority before attorney-client privilege documents.
Has the department volunteered to review by our staff?
Has the department waived their?
Yeah, I mean, have they said we will let you look at these to make a decision on our way or the other?
Well, they would have to waive attorney-client privilege.
Well, they'd waive it to you.
Excuse me, can I ask a question and you can tell me no, but I think I asked it in my remarks and you just raised it here. And it should be easily explained.
Yeah, I should.
Okay, all right. Mr. Edwards, yes.
So, and this is in my comments as well, is you just said that if it involved trade secrets, just to clarify, we're not asking for privilege to be waived. We're saying explain why the privilege applies. Second point is, you just said that if it's a trade secret case, you guys have jurisdiction because it falls within 2273 or whatever that number is. I'd like to point out, Department of Revenue claimed an exception from disclosure under the attorney work product, which falls into 227 sub 4. And so the IPIB report says they don't have jurisdiction over attorney work product, but that's clearly within an exception under 227. So I don't know how you square that with what you just said.
Well, to EJ's question and maybe to Alex to answer to this, my question on this is whether or not
the request from Mr. Edwards of a log or whatever you want to call it, very specific outline of a justification. If it doesn't exist in the form that he's requesting for, if there isn't a record, we can't compel Treasury to create a record to make this work. And maybe this is part of this that simplifies the request. If there's a request for a record that doesn't exist, at least in the form that Mr. Edwards is requesting, or that it could have been an oral thing. I mean, maybe this is a question for the Attorney General's office. If there even is a log, however you want to refer to it, a justification document for each one of the withheld emails, we don't have the authority to require them to generate one.
And if I may jump in and answer your question, no, there is no document specifically outlining each of the emails that are being withheld, specifically not to the detail that Mr. Edwards is asking. I have given you the summary of the general scope and content of those emails, but there is no specific document with the date, time, who, and all of that jazz. So no, that document does not exist.
I find that curious because.
Sorry, Mr. Edwards, Mr. Edwards, this is for board discussion and for us to ask questions of you, not for additional commentary. All right.
If I may I ask a question?
No, it's for the board discussion right now.
Question for Erica.
Yeah, I used to work at Rancho. Gotcha.
Erica or Alex. The court has a question about attorney-client privilege. The court can review the documents in camera.
Correct.
Determine whether, is there any precedent or authority for the board doing that?
There's no authority for IPIB to do that.
And there's no precedence either.
This is exactly the issue. When the ombudsman wanted to review the closed session tapes for IPIB, when they were getting attorney-client privileged communications, we would not release it to them because we would have to waive privilege. They have the same level of review that we do. This is a longstanding, I understand that Mr. Edwards is, there could be a difference. Work product is included in chapter 22.7. Attorney-client privilege is not. Perhaps there is a document or two that maybe is different, is a work product, but is not attorney-client privileged. But I guess I would leave that to the Department of Revenue to say if there are actual documents that would be work product, but not attorney-client privileged as well.
They stated in
They
their
state-
brief to us that they're all attorney-client privileged as well.
That's not what it states. It says. and
No, Mr. Edwards, this is just for the board, please. Thank you.
So unless they waive it, we have never stated that we have authority to go through and look at attorney-client privileged, similar to closed sessions that are held for attorney-client communications.
I understand that, Eric. It seems like to me, and we talked about this in a different context, but there ought to be some mechanism in place where our staff, IPIB, could act as an arbiter to say yes or no. And the parties.
Yeah, I mean,
I understand what you're saying.
That sounds like a rule committee for legislation and maybe.
So, I mean, if they were saying that, Monica's not an attorney, if she had communication with Joel, who's not an attorney, certainly we would, wouldn't qualify and we'd be able to say that, but the actual communications themselves, if they are between attorneys.
Right. If Barry and EJ had communications, we could request that.
If they're if there's communications with our attorney general representing the board.
Right.
But if the request is for justification, that's more of a request for information than it is for a record.
Correct.
That's, I think, where I keep coming back to this on this, is if it's whether or not they should have been held properly or not, I think it's not really the case here. Is there a record that can be provided that demonstrates why each of them was held back. And if there isn't a record.
I don't think that's required.
Right. But I mean, that's what I'm saying. If it's not required and it's not held, then I think that for me makes it a lot much easier. Because I have the same concerns as EJ, is that you shouldn't be able to just say, trust us when these are protected. I don't like that at all. And I think it's actually a very fair suggestion for the legislative committee to take under, next year. But I do think that if there isn't a record that justifies these, then that's it. You can't compel someone to provide a record that doesn't exist.
For me, it's going to be an issue for some time.
Right, yeah.
Figure out how to get through it. And
Some legislators.
maybe legislation is the answer, but I'm sympathetic towards the parties, cases like this.
It's not the first time that we've had,
No, it's not.
yeah.
But I do think there ought to be some way we can hold out transparency. There's not, obviously, and I'm not arguing. I'm just saying I agree with Eric if there's not, but I wish there was somehow or other. There's a check and balance. But anyway, I get it.
All right. Do I have a motion and a second?
May I add, and I know.
No,
it's
sir.
the issue.
No, we're in
The
the,
Department of Revenue determined that
Excuse me.
4,300 documents should
Could
be
you
withheld, and
add-
they're saying they have no
Could you please-
documentation or substantiation for that.
can you meet him, please? All right. Do I have a motion and a second on this case?
Motion to accept staff recommendation.
All right. I have a motion. Do I have a second?
Second.
All right. I have a second from Joan. All in favor?
Aye.
Aye.
Abstain.
One abstention. All right. Thank you very much.
Thank you guys so much. Appreciate the opportunity to talk to you.
All right. I need a 5-minute break.
We're gonna take a 5-minute break, everyone. Thank you.
probably like,
I mean, my cat's in Clementine, so I don't know if I can really.
That's funny.
All right.
Yeah.
That's a cute thing.
All right. I like
One more.
1 minute?
About one more minute. I can answer something for.
I think it depends on the cat though.
Something fancy.
You gotta see like the cat before I could judge the naming. Oh, you named your cat Peter.
Your cat's name is Peter.
Well, they assigned him that name
You're
in the
gonna
shelter.
maintain it?
We might. The reason why is because my husband's name is Gwen. And so Peter, Wilson said Peter Quill in Star Wars from Ben.
Yeah.
Thank you. See, no one
That is deep.
Yeah.
I would not have caught that reference.
I wanted to name my cat Tinkerbell, but my roommate at the time was like, "That's my cat's name at my parents' house." I was like, "Drama." So we stuck Clementine.
Clementine is really cute.
Yeah. She's such a clem, so it's fine.
Oh,
Yeah. 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 Little clemmy. She's a little old lady. She's so.
Oh.
She's fun size, 6.5 pounds.
Oh my gosh, oh, she just, what is she? What is she?
No, she's just a tabby. She's just, I would say it's just a recipe. She's just a little gal. She's the biggest size because she's so small.
Gotta see how domesticated I am. I'm an expert.
Well, she doesn't like other cats. She hates my parents' cats. I like their dogs. But
Okay.
like, she's so old.
Good?
I don't
Okay.
like-
All right, let's move to Kenneth Brown and concerning City of Sydney, case number 25 FC 0050.
Streaming.
I never stopped it. I just.
Yeah, she just,
Oh.
But they did hear your conversation about your cat, so everybody knows your cat is named Peter now.
And
And they're happy to know that you were not talking about anything unrelated in a.
They'll probably ask you for a copy of the tape, so.
All right, so Mr. Brown filed this complaint stating the city violated Iowa Code Chapter 21. The essence of his complaint is that an agenda item stated discussion/action established public works director position was on the agenda. The city at that meeting approved the hiring of a person for a position that had not previously existed, so it was not proper notice on the agenda. In looking at this, he also argued that they were required to advertise the position for veterans to apply, but that is outside our jurisdiction. So we did not accept the complaint for that. The essence of his complaint is essentially that the city should have been more specific to indicate the position would be established and an individual was to be appointed to the new position. Iowa Code Chapter 21 requires notice of what the city was planning to discuss and take action. The agenda clearly indicates a new position in the city was to be considered. The city was not necessarily required to have included the name of the person to be hired for the position. Iowa Code Chapter or Section 22.718 allows for applications from external candidates to be withheld as confidential. And so it's not unreasonable for the city to not include the name of the individual who would potentially be hired in the position if the position is established. While it might have been preferable for the city to do the two deliberate and vote in two separate meetings, there's nothing in Chapter 21 that would have necessarily required it because the agenda included notice of a position to be created. Iowa Code 22.718 allows for confidentiality of candidates for employment. There's no violation of Iowa Code Chapter 21 by the city. It's recommended that IPIB dismiss the matter for lack of probable cause.
is Mr. Brown online?
I do not believe he was going to be able to make it, but he did provide comments.
Okay. If everybody would read those. The city of Sydney, is there someone from the city who would like to respond?
Yes, go ahead, Bree. You just need to unmute yourself.
It's nice to be able to work technology.
Yeah. All right. Yes, you have 5 minutes. Thank you.
Thank you. Yes, what a long meeting. And Erica, we are going to miss you. I've enjoyed, I'll reiterate that, the kind comments. You've done a good job in the position. I would just point out, I agree with the suggested disposal of this. The agenda was drafted and provided sufficient notice to allow the public to have an understanding of what was being discussed at the meeting within the purview of IPIB board. That's the only matter to be considered. And I don't believe that there has been any violation. So we agree with the recommendation.
Thank you. All right, board discussion. Anybody have any comments? If not, I'll call for a motion in a second.
I'll move, we adopt board's recommendation of dismissal.
Staff's recommendation.
Staff's recommendation of
Okay.
dismissal.
All right, I have a motion and a second to accept staff's recommendation.
Did Luke second that?
Jackie had it, I think.
Jackie did.
Jackie had it, yep. Any other discussion? If not, I'll call for a vote. All in favor?
Aye.
Aye. Any opposed? All right, next case.
All right, Kayla Brown and Kirkwood Community College, case number 25 FC 0062. In this case, there was an allegation of a violation of chapter 22. Ms. Brown submitted a records request for emails and calendar entries between certain employees at the college. Within 7 days, the college IT manager provided an estimate of $620 to fulfill the request and provided a summary of custom data pull at $50 an hour, processing 10 hours, et cetera, for a total of $620. Ms. Brown alleges the charges are unreasonable and excessive in violation of chapter 22, and that she alleges the estimate is in retaliation for an investigation with OSHA between Brown, her spouse, and the college, and that the charges are intentional to keep them from receiving the records. Staff reviewed this and was provided a copy of the records request made to the college. The request sought email communications from October 20th of 2024 to May 9 of 2025 for 10 named college employees involved in public safety, human resources, facilities, and others. The request sought all emails with communication between any of these individuals, including subject lines, dates, addresses, attachments, etc. And it also included calendar entries for these. In addition, the request included all communications for 16 broad terms, such as complaint, discipline, refusal, and others. The request also included a broad request for records related to Alex Brown's job duties, protected activity, or work refusal. In reviewing this, there are essentially 1,600 employees of the college. It's not unreasonable to assume it would take time and effort to program a search to include the parameters identified by Brown in pulling these emails to these specific individuals, as well as the broad search terms over a period of 7 months. It's also not unreasonable that it would take hours to retrieve and pull that information, and the hourly rates of $50 and $20 for this IT work is certainly a reasonable rate for the individuals doing the work. The college also stated that it was the actual costs of performing the search and pull of the records of $620 of employee staff time. Based on the request, it does not seem per se unreasonable. And Iowa Code Chapter 22 requires the reasonable expenses be based on actual costs. And even the court has stated that retrieval fees may in fact hamper access to public documents, but as long as they're based on the actual cost, that is appropriate. There's no evidence that Brown's allegations of the costs are retaliatory. The request was signed a concerned member of the public, and all communications were to be sent to an anonymous email address. Based on the request and the breakdown from the college, the fees requested do not seem unreasonable. Ms. Brown can pay the estimate and receive the records, or work with the college to revise the search to reduce the costs. Based on this, we are recommending that the IPIB dismiss the matter for lack of probable cause to believe a violation has occurred.
Is Ms. Brown on the line?
We do not have anyone but board members and Mr. Nocera on the line.
Okay, all right. Board comments?
Move the adoption of staff's recommendation.
Second.
Joel Beach and Barry today.
Give it to Barry.
Oh, give it to Barry. Okay, so all right.
Wow.
Oh, wow, look at that. All right. Any other Any further board discussion on this? If not, I'll call for a vote. All in favor of staff recommendation?
Aye.
Aye.
Aye. Any opposed? Great, thank you.
All right.
Excellent.
The next case, Alex is going to present this one for the board.
So this is 25 FC 0063 Miguel Puentes versus the city of Davenport. So this complaint was submitted May 28, 2025, alleging that the city of Davenport and the Davenport Police Department had violated Chapter 22 by withholding particular records. So they'd made a Chapter 22 request for records from the city's license plate recognition system relating to a particular Illinois license plate and vehicle from November 10th, 2024 to December 10th, 2024. It was made on behalf of the Office of the State Public Defender in relation to an ongoing criminal matter that Mr. Puentes was responsible for. In response, the Davenport Police Department asserted that the document in question did not exist, and if it did, it would not be confidential. Sorry, it would be confidential pursuant to 2275 as part of a police investigative report. The original complaint, the reason why we accepted it was because there was a question about whether the broader investigative report might be disclosed under other rules, and whether they were seeking it. Once we did accept it, however, it became clear that the primary or the only record that was explicitly being requested was the information from that license plate reader. And under our precedent in the case 23 FC 0127 Van Pelt versus City of Clive, which reviewed similar requests for footage recorded by another city's license plate recognition camera, we have determined that Iowa Code 22.755 applied. That is the exception for an intelligence assessment and intelligence data under Chapter 692, except as provided in Section 692.8a. Intelligence data is defined to mean information on identifiable individuals compiled in an effort to anticipate, prevent, or monitor possible criminal activity. And so the determination that we came to, which follows closely in line with our precedent in that Van Pelt case, is that the data, the sensor data in the LPR cameras was covered within the scope of that exception. That is to say that sensor data collected by the city qualified as data or information. The records were compiled for the purposes of anticipating, preventing, or monitoring possible criminal activity, which allowed the police department to receive notifications and investigate further. And then the third prong is that the license plate and vehicle information captured by the devices qualified as individually identifiable characteristics. All of those were essentially the same conclusions in the other case. And so our recommendation is that it is confidential. They were allowed to withhold those requested records, even though the records in question related to Mr. Puentes' client. And on that basis, we find that there is no probable cause for a violation based on their decision to.
And does not appear we have Mr. Puentes or the city of Davenport.
From Teams, Amy Sheehy. I didn't get an answer
Sorry.
soon enough, so to be safe, I pulled Russell 5 million, and
Sorry.
we'll send that tomorrow to Senator.
Wow. You got an Australian on the
Sorry,
line?
yes, I do. Yes, I do. I'm Irish. Sorry about that. Okay, sorry.
Okay.
Board discussion on this one? If not, do you have a motion and a second?
Motion to accept staff's recommendation to dismiss.
Motion by Luke, second by EJ. Any other further board discussion? Not all in favor?
Aye.
Aye.
Aye. Any opposed? All right, next case.
All right, this is Alicia Beers and the City Council of Pisgah. And Ms. Beers filed a formal complaint alleging the City Council violated Chapters 21 and 22. The Chapter 22 issue was resolved when she did receive all of the records after review by the attorney. The Chapter 21 issue is that a claim that there was an illegal meeting to sign a letter seeking her resignation from the council. The council, responded through their attorney stating that, no meeting occurred. The mayor spoke individually to council members and stated he left a letter at City Hall. If any member wanted to go and sign it, they could. Ultimately, the council members did sign the letter and that was mailed to Beers, but no official action was taken. She alleges there was a walking quorum because members signed the letter. And she should have been notified about the letter because she was on the council. However, in looking at the evidence, there's no evidence a majority of the council at any time deliberated on the letter or the language of the letter. They did provide notice of a June 5 meeting to deliberate and potentially take action on her position on the council. While it would have been preferable for the council to address the matter in an open meeting without sending a letter to her, no facts have been presented to establish that a meeting occurred prior to her receipt of the letter. Based on this, it's recommended that this be dismissed for lack of probable cause to believe a violation has occurred. Ms. Beers did provide some comments.
All right. Let me take a minute to look at the comments first.
I guess the correct definition of walking quorum in here. I've never heard of that before.
A walking quorum is something that at one time, the legislature looked at, but they never passed anything. And so there's never been anything that finds a violation one way or another. The court has not found that a meeting can be created through a walking quorum. So,
and that would be like, you would talk to me and then.
So, I mean, if the court has found in the Hutchison Shoal case that because there were three board of supervisors and they utilized the city administrator to kind of develop stuff without having two of them together. So they used an agent as a proxy to try to get around the Chapter 21, but I'm not aware of any cases in which individuals going and signing a letter one at a time creates a quorum or a meeting.
Thank you. I just never heard of that.
I agree with the recommendation of staff, but this is puts the complainant in the position of proving a negative, and it's unfortunate. But I agree it's not a walking quorum, but it's certainly not the way to do business.
Yeah, I mean, there was also, it's not, I don't believe I put it in here, but there was also a recording from the June 5 where they say there's no meeting or there was no meeting. And
so you did have some
evidence. I mean, as far as them saying there was no meeting, so, I mean.
Okay.
I know. This feels a little like the 2x2. I mean, I really don't like it. I think it's really crummy. And that was even before I read her letter.
Yeah.
So, I mean, if you guys wanna, my recommendation, but you're the decision maker, so.
The worst part about this one is I mean, you can't prove, and the other council members say that it didn't happen. I mean, she didn't resign, did she?
She did not resign. There was a meeting on the 6th or 5th or whatever it was. I think she thought that I thought that they removed her, but then she said that she wasn't removed. So I think that there's probably some issues, but
that's beyond her.
But that meeting was properly noticed. It was on the agenda. We attended that meeting.
All right.
I'm okay with dismissing, but this might be a good one to offer some friendly training.
Yeah.
On how to do.
I would agree with that. I think, while technically you don't know what was talked about, is just not good practice to handle something this way because it has the appearance.
Yeah, it's got a very bad appearance. And all right, do I have a motion and a second?
I'll move to approve staff's recommendation of dismissal for lack of probable cause and direct staff to reach out and offer a training to the city of Pisgah.
Where is it Pisgah or Pisgah?
Pisgah,
Where is that?
no idea.
Okay.
Probably over by
I'll go,
Council Bluffs.
C.W. McCall. Old home bread.
That's right. That sounds northeast.
Oh. Oh. Okay. I have heard of that before. Okay.
For you younger.
I have no idea who that is
No, you
either,
wouldn't know. No, you wouldn't. Okay. All right, I have a motion, a second on the table. Is there any other board discussion?
Who was the second? I didn't catch that. And Kim didn't catch it. Joan, did you make a second?
Yeah, Joan made the second on this one.
Joe's like,
No, Joan doesn't. Joan is taking.
No,
I
or
just
was-
commented.
oh, you just, okay, sorry. Okay, I have a
Okay.
motion on the table. I apologize.
We'll second it.
Do I have a second? All right. All in favor of staff's recommendation and to reach out to the city for additional training?
Point of information, just, is this a friendly offer for training that you're
Yes,
directing?
yes.
Just wanted to make. sure.
Yes, a friendly
Okay.
offer of
A hand on the
training.
shoulder.
Yeah,
Yes, we'll have Luke call them.
or maybe a slight push, but they really should have some training to know. All right, okay. All in favor?
Aye.
Aye. Any opposed? All right. Next.
All right, we've got the matters withdrawn. And then we have the contested case proceeding update and information, take actions necessary. I would ask, because we do not have the council for Pleasant Grove Township trustees here, I would ask Kim and Alex to step out so that there are no
Yes, thank you very much.
Take my phone. All right. Good luck.
All right, so this was filed on July 9th, 2025. I provided a copy so that you all have it. I also provided the Q and As from March of 2017 from the Attorney General's office regarding contested cases. Just so everyone is aware, we are, working with them to see if there's a way to find a settlement of this. But because something has been filed, we do need to move forward. So I need to know how you guys want to proceed. We do not have a specific time determined for the hearing. And we can, right now it says that the IPIB will serve as presiding officer at the hearing, but we could hire an attorney, could decide to hire an administrative law judge to help you through the procedure of it, to help you write the opinion and go through the hearing if it should occur. Because there's been quite a bit of time between this contested case and previous contested cases this board has had. I would probably recommend, especially with the new director coming in, that you do reach out and choose to hire administrative law judge who then can go through the procedure of setting the hearing, working with the parties on anything that needs to be done before it comes before the board for a decision.
I would also recommend that because it has been, how many years has it been? A contested case.
Oh, it's been a long, long time.
Yeah, I think.
Shortly after.
I do not know what
That's
it
what I think
costs.
so
I do
too.
not know the process, so I would, that would be up to you. I assume you could just call Department of Inspections and Appeals and Licensing, who has all the administrative law judges.
I just approved a bill for them and I want to say it was like $90 an hour or something like that. It wasn't.
It's not,
anything exorbitant.
yeah, it wasn't, I'm trying to remember who.
Take it
Barry,
out.
I don't even think you were on the board our last contested case.
No, I don't remember.
We can do Barry's per diem.
Yeah. He just nominated you to take over and in charge of the contested case.
I can't. I'm the vice chairperson. I can only do one thing at a time.
So, so I mean, I don't think that you need to do more than just, if you're gonna do that, maybe take some action to hire.
Yeah.
That, but I don't think there's anything else at this time that you need to do on the contested case.
We don't need to set a date or anything.
Dial will do it.
Yeah.
I would say, you know, we'll inform the attorney that we're gonna hire an administrative law judge. That person would handle between the prosecutor, Alex, and the attorney for the township would handle any procedural issues, setting that hearing, those kind of things.
You know who the attorney is for the township?
It's the county attorney.
I didn't see that.
He did speak for the township when this was before them. Or before you guys.
Yeah. I think we should hire an administrative law judge. I know we did that with our last case as well. I honestly cannot remember what the case was. I think Mary Ungs was the chair at the time. So I mean, that's been.
Oh, yeah, that's. So I think it was shortly after I got on board.
That's what, yeah, because I think you and I came on about the same time.
I think it would be in your interest to hire. an administrative law
I would
judge,
agree.
especially with all the other stuff going on.
Yeah.
Do I have I think we can make a motion to do that. I think we have that, don't we?
I believe that would be take
Okay.
actions
Yeah,
necessary.
okay. Sorry, I should have looked closer at that. I was just, yes. Do I have a motion and a second to hire an to direct staff to contact Iowa Department of Administrative Services? I think, right? IDOLS, yeah. To hire a administrative law judge to handle the contested case.
So moved.
Second.
I have a motion and a second. Any other discussion on that? All in favor?
Aye. Aye.
Any opposed? All right, so yes. And Charlotte, guess what? You get to spend some money.
All right. Anything else that we need to discuss on this, or can I bring staff back in?
Yeah, you can bring it back in. I don't think there's anything else.
Erica, do we usually set these during a regular board meeting? Is that?
I would say that probably is the best way to do it, because you guys already have the dates and times, but again, that would be up to the ALJ to.
Yeah.
I think that's how we did it last time. But like I said, it's been probably 8 or 9 years. Because I think one of the first cases that I had was a contested case. So it's been a long time.
Seems like it could be, a long meeting.
It probably would. I mean, the other thing is we do also have the ability to be remote. So,
Yeah.
it does give more ability to meet.
I think it ought to be a special meeting, and I think we ought to do everything we can to get the board members here in person if possible. Yes, I understand we can do it remote, but if you're gonna have something like this, I think we should make every effort we can to accommodate the board.
I will put EJ's, you note EJ's preference for a special session.
Which means you can ignore it.
All right. Anything else?
Nope, I think that's it. Yep.
Yeah. Alex?
Other than I want to know if Alex gets paid by the page.
Yeah. Looks like he does.
It was, we've had some large.
Tell him.
Before,
Oh, I think.
but it's been
I
a
assume we're
while.
fired.
No.
I try again.
Well, Kim, yes, of course.
No question.
You got too much seniority.
All right. We're on committee reports.
Yeah.
Training.
Yes, all right. So we have a lot to discuss from training, mostly related to House File 706. Some of it was covered already during this meeting, so I won't go into too much there, but essentially we have 4 trainings that we're going to be conducting online. They've been very popular, very high in demand. We've been getting all sorts of emails on both my personal work account as an attorney and on the IPIP account. We've just been getting contacted, inundated with questions. And, with that in mind, we have 2 dates set up for August, 2 dates set up for September. I believe, as Erica stated at the beginning with the update, is we're going to continue with that schedule for the foreseeable future. I think it'll be, I'll talk to Charlotte about this, what exactly we need to do in order to meet the needs of all these different government bodies that are reaching out to us. One of the things that we discussed during the training committee session was our approval of the different government bodies that are reaching out to us. We have obviously the one from the Iowa Association of School Boards, but we're also, at least it's our understanding, that the Iowa League of Cities should be reaching out to us, not to put any pressure in terms of bringing that up to the public, but we should have other people helping us to meet that burden. Of course, we have 3 full-time staff members at full capacity, so in order to get that statewide implementation, we're going to need help. But I think that we're going to get there. And then the other consideration that's on the table, I think once we have one of those under our belt, when we've actually done 100 different people and they all come in and they ask questions and we see how that runs, I think we'll be able to plan a lot better for the future. But our pilot training, since I don't think we've addressed that at a board meeting yet, even though we discussed it in training committee, I think that went well. We didn't have any significant issues with registration. We got some insight into what needs to be included with our abbreviated training. Obviously, I'll be looking at that before we deliver our next training on, I believe it's August 15th. And then I will have, because I believe August 21st is the board meeting next week, I'll be able to speak more to that then. We also, just in general, as the last update from the training committee, just in terms of training, we have so many trainings scheduled for August in addition to 706. So I'll be driving around. I will be talking a lot and my voice may be sore by the 21st, but we'll get through it.
Legislative, no update. Although you guys did identify a couple things that your legislative committee might want to work on, I would recommend, if you're going to do that, maybe starting sooner than later, but you do have a great director now who knows a lot about drafting legislation, so you should be in good hands there.
All right, Rules Committee. There is an action item for the board related to Rules Committee today. So I'm just going to give you a little overview. Your Rules Committee met today to talk about where the rules are in the process, and they are recommending that this board move the rules to the next step in the rulemaking process, which is actually getting governor approval and filing a notice of intended action of those rules. Where this comes from, as you may recall, the regulatory analysis was published for all chapters. The first public hearing on regulatory analysis was all chapters with the exception of Chapter 8. There was no public comment. This week, the regulatory analysis public hearing for Chapter 8 occurred. Again, there was no public comment. Now, I contribute that to the fact that we outreached to stakeholders. All stakeholders had the opportunity to review, provide feedback. It was all positive. So I think that's really what's underlying not getting public comment. So there was no changes to any of the rules which are in the regulatory analysis. The regulatory analysis are all on our website as required by EO10. So based on that, the Rules Committee is recommending that the board make a motion and approve to advance the rules to the next stage of the rulemaking process, which again is that notice of intended action. I don't know if any of the Rules Committee members have anything to add to that, but that's the update based on the committee meeting today.
I just think Joel did a hell of a job.
Well, thanks to Kim.
Yeah. Kim took the lead and did a great
Kept us
job.
on time and.
All we had to do was say yes. Joan was chair. She should be speaking on behalf of the committee. You
I
represent,
would like to be there. There is a person with a chainsaw outside my window. He might be related, but I'm not happy. I can't hear. Carry on.
All right, is there any other comment, or question or discussion on that? So, do I have a motion and a second to advance the administrative rules to rulemaking?
So moved.
Second.
All right, motion from Luke, second from Barry. Any other discussion or comments from the board? If not, all in favor?
Aye.
Aye. Any opposed?
Erica, can you go back to legislative? Do you have on your list of potential issues this question about being able to ask for further information when the attorney-client privilege is asserted?
I was not keeping lists because I thought you were keeping the list because you're in charge of legislative.
I'm not.
Oh, we're in trouble.
The chairperson.
Making vice chair, he's out.
All right, so you asked for ability to review the attorney-client, and then the other issue that came up was the issue of 22.7 5 as it relates to active cases
Yes, absolutely.
that haven't gone to trial.
Thank you.
I think they're long shots, but
Well, Charlotte knows people who knows people.
yeah, I know.
I think the attorney-client privilege issue is really, so there's a huge gap in our authority. So
I agree wholeheartedly, and I think, I'm not sure. Monica says it's a long shot. I'm sure it's a long shot. I think our job is to put it out there as a problem so that we can be more effective at what we do.
Yeah.
So I urge that we can pursue that. Absolutely.
I don't disagree, and I think it's important that we attempt to get it. I just have a whole reservation about what attorney group are we going to be able to get on the bandwagon to say, yeah, let's do this?
I know who'll be against it.
Well, I do too, but, yeah, so that's just you gotta attempt it, you gotta try it.
But I think if we get it out there and we get a lot of opposition, we may get some folks. We have the opportunity to explain to folks why we can't be more effective than we are. And they may assist us in getting something more done than we got now. I don't know, but I'm a firm believer that we're charged with the obligation to continue to press those kinds of issues.
Absolutely. And even if it's the problem of the log, like being able to justify it, even if you're not reviewing it, having some sort of requirement to be able to justify it would be immensely helpful.
The other thing I think, we've talked about this, I don't know if anybody else remembers the discussions, but that is a period of time that government should keep emails, retain emails.
Yes.
What ends up happening is we see so many times emails get quote deleted, quote, probably 20 minutes after they know somebody's asking, but
Text messages as well.
yeah,
Went through that.
the whole gambit of ET communication. I think governments ought to be required to keep them for a certain period certain, whether it's 60 days, 90 days or whatever. But there've been too many times you say, oh yeah, we'd love to give that to you, but it was an email and we got rid of it. I think that ought to be an issue as well.
Yeah.
Retention of.
Maybe we're special, but if you delete it, even if you delete it out of your deleted, people still find it.
They couldn't find text messages during COVID.
Text messages might be different.
those are harder to retrieve.
Text messages,
Yeah.
because they're not retained by the cell.
Uh-huh.
That was, a different issue.
Yeah, but that's part of the communication, and that was part of the issue that we had.
I agree, we go after all of them.
Yeah, you guys are gonna have a lot of fun in your legislative committee.
We're going to have it next. We got fines.
I might even log in to listen and provide comments.
Um, we also sort of have this metadata issue out there too.
Very.
Oh, man, and you guys wonder why I'm leaving.
Don't ruin a good time.
Solve the whole world's problems in one meeting.
Barry, Charlotte doesn't start until tomorrow. Be quiet.
All right.
Right down.
All right, quickly, I'll go through office update. I'm out of here. You guys, you're welcome. Kim's position has been advertised. It was advertised, the 15th. It closes on the 5th. So if you know any good attorneys, have them apply. We've got 2 applications already for that. Finance.
We
3?
just got the third.
Oh, okay.
Oh, good.
Finance, budget update. I did not bankrupt this agency. I want that on the record. There is a little bit of money left over at the end of the year that will go toward, the technology and training. We made sure that we had a little bit left over so we could still pay for Salesforce if we didn't get any additional money from the legislature. With the move here, it was going to cost more and blah, blah, blah. But now that I'm leaving, Kim's leaving.
We'll go first and then I'll go into my notes.
Well, we're going to be
Hey,
just
Tracy,
fine.
from Greg Order.
So-
Thanks everybody for giving me a couple of seconds to lead of your awesome meeting.
Jackie, can you mute?
To give a quick update from the lynch front, if you hadn't seen the news. Sorry, my Apple things are way more sensitive than I thought.
Okay, so there is going to be a little technology and training. There is also some money to hire some help with House File 706 if they need. Presentations training. We have talked about House File 706. We do have our August 15th. We're currently using Eventbrite until the state can get us set up on a system for our own registration and review. Eventbrite is not great, but it's free, so that's what I like. Our August 15th training to hold 100 people sold out in 48 hours. So we've opened up August 26th, September 10, and September 24. Those will open 30 days. Eventbrite won't let us open registration more than 30 days in advance, but those all have 100 spots. Our guidance is out on the web. Our approved providers is out on the web. Our dates for our training is out on the web. And I would ask anyone who talks with government bodies to remind them that the mandate is for newly and elected and appointed after July 1. It's not every person. So there is some time to get training for that.
And appointed does not mean hired. Right.
I do not believe it means hired. I believe it means like a commission or a committee. All right, district court updates. You've got some appeals going on, but nothing is active. If there's anything that John needs, he knows where to find me and he knows how to find you guys. So hopefully, I don't know when the Supreme Court starts their new term, but maybe you'll get a decision on the Tig v. Loeffler case and everybody will get. Next board meeting, August 21 at 1 p.m. That's all I have.
Barry, you want to call the adjournment roll?
So called.
All right.
Done and dusted.
All right. Thanks, everybody.
Thank you all so much for letting me.
I'm glad you got in on the marathon session and.
Oh my God.
Barry needed to be here again, so we can have a short meeting. It's all your fault, Barry, because I came from Eastern Iowa and you stayed there.
Okay.
Roasted. I love it. It's a tough day for Barry.
Yeah, I know. No kidding. Geez.
Yeah.
All right.
Let's, we love you, Barry.
Calendar with
Bye.
Always glad to help. See you in August. Bye.
See you, Barry.
Coffee with Catherine at 10, and then 9 o'clock is when